This is the case of Crowdshout Limited and Crowdshout Holdings Limited. The claimants, defendants are Nova Scotia Limited, GCM Holdings Limited, Digital Technology LLC, Hearn Holdings Limited, Gabriel Craig Murphy, Regina Murphy, and Integrated Capabilities Malta Limited. So, can I just see who is here? Mr. Halsall, you are for the claimants?
That's correct, sir, yes, thank you.
Now, just remind me, Nova Scotia Limited is not represented here, but
we actually act for them, but they're not appearing in the proceedings, and they have filed acknowledgements. They've indicated they're not playing a part in the proceedings, sir, and they don't oppose any of the relief sought by the claimants. That company is the nominee company of Integrated Capabilities, and is ran by their directors, and they're the directors of Crowdshout as well. They provide the directors of Crowdshout.
Righto. GCM Holdings Limited now. Mr. Murphy, you represent GCM Holdings Limited. You've been given leave to appear for them.
Yes, Your Honour. I'm here on behalf of GCM Holdings Defendant Number 2.
That's it. Thank you. Digital Technology LLC. What's the position with them?
Yes, Digital and also Hearn filed acknowledgements of service via Long and Humphrey last year, and they indicated in their covering letter, and this is dealt with in the evidence, that the third and fourth defendants confirm they do not oppose the declaratory relief sought by the claimants and have no wish to actively participate in the proceedings, and are content to be bound by any orders that the court ultimately makes. For the avoidance of doubt, the third and fourth defendants do not wish to incur the costs of participation in these proceedings.
Thank you very much. So that deals with Holdings Limited. Mr. Murphy, you're obviously here, so you're the fifth defendant. Regina Murphy, now she is not here. Can we just leave her to one side just for a moment? Integrated Capabilities Malta Limited.
They haven't entered appearance. They don't. However, I do have instructions. They don't oppose the claims either, sir. Again, that's dealt with in the affidavit evidence, the written statement, sir.
Yeah. So, as Mrs. Murphy's concerned, I've had an email which was received yesterday evening, so I've just received it this morning from Mrs. Murphy. Have you both received that? It doesn't seem to be copied to either of you.
I've just been given it now, so yes.
Right. You've had this, Mr. Murphy?
Ms. Klein gave me a copy of it too, yes, Your Honour.
Okay. Right. What do you say about this, Mr. Halsall? It looks like she hasn't been served with these notification of today's hearing, is that right?
No, sir. I filed a short affidavit, witness statement on yesterday, because we just received a translation of some Maltese proceedings, and there is an email exhibited there where I've confirmed to Mr. Murphy that she's not relevant to this hearing, as we've decided we're not actually seeking orders against her on the basis that she hadn't been involved with the actions that we allege were wrong.
So you're not seeking.
So if we get that far today, we wouldn't be seeking orders against her anyway.
But she's still a party to the proceedings. She's a defendant.
She is, but she she filed an acknowledgement service originally through Mr. Murphy, but hasn't played any part in the proceedings. And the injunction proceedings were sent to her to her lawyers. I think it's evidenced on the back of this email in May, and she's not played a part in the proceedings. But as I said, so we wouldn't be seeking orders against her anyway, so we don't believe this should delay today.
So your argument is she won't be prejudiced at all by what's going to happen today or what may happen today? I mean, she says, for example, you're seeking costs against her. Is that right?
We're not, no.
She's never been notified of the application or either the application or the hearing. out as a party, shouldn't she? I mean, is that the way to do this?
I think the circumstances have been somewhat complicated because there's been conflicting filings allegedly on her behalf. It's not something we've considered, sir. But and obviously this email I've just received now. But as I said, we don't think it complicates matters in the sense that we wouldn't be seeking any orders against her anyway. So there'd be declarations that we'd be seeking as against Mr. Murphy and GCM, which is his company.
As I recall, though, and I think as Mr. Murphy says, the draft order that you filed for judgment in default does, I think, somewhere refer to...
It does, that's the draft, sir, but having considered it since, we wouldn't be actually seeking any orders against her today.
Right. Thank you, Mr. So what do you want to say about this, Mr. Murphy? Is this like,
Certainly.
Murphy isn't going to be the subject of any orders by this court today? No relief is being sought against her, it seems.
That runs afoul of Mr. Hustle's application, which seeks relief against Rogina Murphy, both in the draft order as well as in the original application. I've seen no amendments of any sort filed that changes the relief requested by Mr. Hustle against Rogina Murphy. In my view, she is an indispensable party to these proceedings. She's necessary. She declares that she is the director of both of the claimants in this action, and it would be highly prejudicial to both my position as well as hers if she is unable to be here for the hearing on the second application. I can confirm that she was never served with either the second application nor with any notice of this hearing. And I asked Mr. Hustle to confirm that on Tuesday, I believe, but I did not hear back specifically on that question. And I apologize, Your Honor. Should I be standing when I address the court? Okay, thank you.
Mr. Murphy, that's fine. If you feel more comfortable standing up, it's entirely up to you.
Thank you.
Well, I'm told that no relief is being sought against her, that the draft order is in fact going to be amended. It's only a draft, and the order will not refer to her in any way, shape or form. So, I mean, we've all come here, and you've come here at great expense and time, and it seems a shame to defer the hearing to some unspecified date when in fact no relief is being sought against Mrs. Murphy. So, I must say I'm inclined to go along with Mr. Hawthorne. I think it's unfortunate she wasn't at least notified of these proceedings today, because she is a party. But if no orders are going to be made against her, I'm not sure where that gets you with your claim, Mr. Hawthorne. I thought part of your claim was in fact to declare, I may be wrong, directly or indirectly, that Mrs. Murphy is not a director of the company.
Well, we'll be seeking a declaration that Mr. Murphy is not,
Right.
and that the directors are my client companies' directors.
Well, Mrs. Murphy may want to say that she is a director of the company.
Well, this is,
In fact, does she not say that?
Certainly she does, if I may, Your Honor.
Yeah.
The attachment,
Yeah, well, she says,
paragraph 1.
Sorry, she says, I am a director of both of the claimants.
And that is a court-filed affidavit in Kansas.
Right, so this is the affidavit, right? This is attached to this email.
Moreover, I believe under Rule 2.24, Mr. Hustle had the obligation to notify Rogina Murphy of this hearing and give her notice of the application, which wasn't done. And certainly I've come all this way. I think the thing to consider is to as this court had originally ordered on the 7th of April to hear the first application and adjourn the second application until the first application is determined.
Sorry, you'll just have to remind me what applications you're referring to then.
Certainly. The first application is the application to stay, Your Honor. Your Honor may recall at the 7th April hearing, Your Honor had ordered that the first application would be heard and the second application would be adjourned, which is the application for judgment in default.
Right.
That's the application, Ms. Murphy.
Yeah, the stay application is logically the first one to deal with, isn't it, I think?
Yes, Your Honor, I believe so. That's my understanding, my interpretation of Your Honor's order. But certainly Regina Murphy asserts that she is a director of the claimants and clearly is an indispensable party as to any declaratory judgment that would say she is not a director of these companies.
Because any declaration I make that certain people are directors of the company must necessarily imply that she is not.
I would think so, yes, and she repudiates the previous affidavit that was submitted to this court, which led to the penal notice that's presently in place. And that's covered in great detail in the affidavit that's attached to the email before Your Honor.
Thank you, Mr.
Yes.
Well, it sounds to me also that there may be some difficulty in proceeding with giving any form of judgment. I mean, that may have been a problem anyway, even if Mrs. Murphy had been notified of today's hearing, because I'm not sure I could give a judgment as it were in default. I mean, that's a matter, this whole issue of who is a director of the company, or who are the directors of the company, what is the construction of the shareholders agreement, the articles of association, that all will have to be dealt with at a contested hearing, I think. The issue of the stay can still be dealt with, surely, I think.
Yes.
In other words, which is the correct forum to decide this issue.
Yes, I think that can be dealt with.
So we can deal with that, because that's a matter of law. All submissions have been made on it. So I could at least deal with that. How far we get with the other issues, I don't know. But,
Well, so I would need to take some instructions on this wit statement anyway. So
well, this affidavit has been around for a while, hasn't it? This one, this declaration. I think I've seen this before.
yeah.
It's in the London.
Yes, Your Honor, I filed it, if I may, I filed it as an exhibit to one of my further suggestions in support of the, actually it's an exhibit to my application to discharge the injunction, Your Honor.
Yeah, it's this sort of,
Yes, sir.
It's an affidavit one would remember because it has some local language.
Yes, sir.
Yes.
I mean, the question is whether Mrs. Murphy would have anything to add to the issue of whether this is the correct forum to deal with this issue. I can't imagine she would. I mean, you've put all the submissions down.
I can proffer that she would, actually. She has been involved in the proceedings in Kansas. She has an interest, a significant interest in this case, subject to our divorce proceedings. The nature of that is sealed, so I can't disclose that, but I can represent to this court that she absolutely has an interest in these proceedings, and obviously she would like to have been here, possibly with an advocate to represent her interests. I can proffer that she does join GCM Holdings in its request for an application, for its request to stay these proceedings. So I think maybe the best course of action to consider would be just to hear the first application today and the first and the third applications today and adjourn the second application for a later date. Once Mrs. Murphy has had proper notice, she will then be able to attend the hearing in the future on application 2.
The first one is for a stay, the third one is for the discharge of the injunction.
Yes, Your Honor.
Well, I think that might be the correct way of proceeding. What do you think, Mr. Wilson?
I'm just slightly confused, Your Honor, because I think my other friend indicated that Mrs. Murphy would want to play a part in the stay argument. which of course is Mr. Murphy's application.
Well, what he's saying is she supports his submission. I mean, basically, she fully supports what he says. So I could take.
Yes.
In other words, I could deal with the state argument today.
Well, I don't object to that, sir.
I think we really must try and
Yes.
today in some meaningful way. Otherwise, it's such a waste of time. Goodness knows when I'll be able to revisit the case anyway. Quite frankly.
Yes.
Okay, well, I think that's the best way to proceed. Any issues of judgment in default, I think, are going to be rather difficult to deal with, Mr. Russell, bearing in mind that Mrs. Murphy is party to these proceedings and to be a director of the companies. But I'm not sure that's going to prejudice you anyway, Mr. Russell, because I think there would have been some difficulty there anyway in making any final declaration. Right, okay, so I think we've reached some common ground. I will deal with the stay application and the discharge of the injunction application. Obviously, if I stay these proceedings, the injunction would presumably, well, I don't know, it might well go away anyway because it would be dealt with in another jurisdiction. But there we are, that's perhaps not for me to say at the moment. So, so far as the stay argument is concerned, then, it's your application, Mr. Murphy, so provisionally, I jotted down here a sort of timetable for today because there's quite a lot to get through, and it needs to be dealt with if at all possible today. I would like, if at all possible, to give a ruling on the matter. So what I was thinking, we're now 20 past 10. If I were to give you about an hour to develop your submissions, something like that, give you to maybe till 11, and then I'll give Mr. Halsall say an hour or so to respond to that. We can then take stock maybe and look at the application to discharge the injunction maybe after lunch. Normally I would break for lunch at around about 1 o'clock, maybe a little bit earlier than that, for maybe 3/4 of an hour, something like that, and we can deal with the injunction application later on. So that's my provisional view. Yes, if I allow you then to speak till about 11:30. I've got to put a timetable on, otherwise, there's 1,800 pages here. We could.
Yes, Your Honor. And I think that's fair. I think I can adhere to that timeline, Your Honor.
That's fine. What do you think about that, Mr. Halsall?
Yes, sounds sensible, sir.
Okay, thank you very much. Right. Okay, Mr. Murphy, you can take it that I have endeavoured as best I can to make myself familiar with the papers. Obviously, it's a case of doing it for a little while, and I am aware in broad terms of the issues. So I've certainly read the skeleton arguments. I've read, I think, the relevant witness statements. If there's any particular documents that you feel I want to emphasise, then please refer them to me. You've obviously got the bundles down in front of you. They've all been paginated, so you can refer me to the relevant bits. So I leave it to you then to develop your argument that this is not the correct forum to deal with this case.
Wonderful. Okay. And if I could just start, Your Honor, by laying a little foundation here. First of all, I want to extend my apologies to this court for my non-appearance at our last hearing. My mother has had some significant health issues that I've been dealing with, so I certainly did not mean to disrespect the court in any way by not appearing. I honor this court's order and have adhered to it strictly. So I'm here today on behalf of GCM Holdings at the pleasure of the court. I also really appreciate that Your Honor has taken the time to read the 1,800 plus pages.
Well, I can't say I've read every page.
Understood. And I can't say that even though I have lived this and authored many of these documents, that I am intimately familiar with every single page myself. So when I refer to specific documents, what I'll do, if it pleases the court, I'll reference the file number and then the page number that Mr. Halsall has put together in these bundles so that it's easy to refer to. And I think Mr. Halsall did a wonderful job of putting this together for everybody. It was a bit difficult for me to confirm the contents from the United States as it was delivered to my local address here in the Isle of Man, and I only received these yesterday when I got to the country.
Right.
So, having said that, allow me, if it pleases the court, to lay a little foundation as to how we ended up here in the first place.
Yeah.
And this goes back to the summer of 2012. I am an internet entrepreneur. I have bought and sold many websites over my 20-year career. In the summer of 2012, I had a letter of intent to acquire a website called video2mp3.net for $3 million of consideration, amongst other terms. With that letter of intent, I engaged Kansas counsel by the name of the Katz Law Firm to represent my interest in consummating that transaction. A little about the website. It's subject to controversy. It allows people to extract out the audio from a video file, hence the name video2mp3, and save that file in MP3 format. In 2012, there was a question as to the legality of such a website. And so as the ultimate beneficial owner of this asset, having privacy protection was of utmost importance to myself. Having relayed this to Kansas counsel, they in turn referred me to, they suggested that I talk to a company called Integrated Capabilities Limited. So in July of 2012, I first was introduced to Kevin John Perks, who is a Manx resident and purports to be one of the directors of the claimants in this action. Mr. Perks sold and induced me to work with his firm and to set up corporate personalities, both here in the Isle of Man and in Malta, that I'm going to refer to as the CrowdShout structure. So I came up with the name CrowdShout, and shortly thereafter, I believe in July of 2012, CrowdShout Limited was formed here in the Isle of Man. Shortly thereafter, its parent company, CrowdShout Holdings, was formed in Malta. And then in August of 2012, that transaction whereby the website was ultimately consummated, specifically August 20th of 2012. And so CrowdShout Limited ended up buying that website. Through that transaction, there was a plethora of documents that were executed, some of which are subject to the main controversy as to who controls the claimants, including the shareholders agreement of CrowdShout Holdings, including the consulting agreement between CrowdShout Limited and Westmark Capital. That is a key document because the directors here in the Isle of Man, or those that purport to be the directors of CrowdShout Limited, will say that they don't know how to operate the website. So ultimately they needed to have a consulting agreement with me, the entrepreneur, who knows how to operate the website. And so that was the purpose of the consulting agreement. And that consulting agreement was how I was able to earn income and support my family.
And that's with Westmark, is it?
That is correct, Your Honor. Westmark Capital is a Kansas entity which is wholly owned by GCM Holdings.
Yes.
One of the documents that was also signed at the time were a number of promissory notes. One was with a company called the Richard B. Katz Family No. 2 LLC, a Kansas entity. It's undisputed that this Kansas entity lent money to CrowdShout Limited for the specific purpose of purchase money funds to acquire the website. So as I mentioned, the website was bought for $3 million. $1 million consideration was paid at the closing, and part of that $1 million purchase money came through a promissory note that CrowdShout entered into with the Richard B. Katz Family No. 2 LLC. This is a very significant document in this whole dispute because I believe that there is clear forum selection language and choice of law provision within that promissory note. That promissory note was executed by both CrowdShout Limited and CrowdShout Holdings Limited as well. It is one of the documents that's in front, that is within the bundle. And let me just go ahead and refer Your Honor to that, if you'll give me one moment. It's going to be number file 5 of 5. Page 1766, Your Honor. This is a copy at the top of page 1766 of the foreign language that I'm referring to from what I will call the Katz note with the Richard B. Katz family number 2. I also attached a full copy of the promissory note, and you can see that very language reiterated on page 1783, which is a copy of the note itself. I'll give Your Honor some time to flip there.
Yeah. So this is, right, so the promissory note itself was governed by Kansas law, and presumably any disputes about the note would be brought in Kansas, is that right?
Well, if you read the language here, it says that this was a transaction negotiated and consummated, so I'm talking about the purchase of the website, in Johnson County, Kansas. This agreement is dated, by the way, Your Honor, August 10th, 2012, which is the exact same day that the consulting agreement's dated, amongst many other documents, including the shareholders agreement for CrowdShout Holdings Limited. You'll note that the language says that any, give me one moment, Your Honor. Section 4, IV, agrees that any legal proceeding against any party to this agreement arising out of or in connection with this agreement, and that's the key language, arising out of or in connection with. So if we look at this promissory note, we flip to the next page, keeping that in mind. We have on page 1784 the signature of both Kevin John Perks and Robert Arthur Cannell, who were undisputably the directors of CrowdShout Limited and CrowdShout Holdings at the time. And so in connection with this agreement, we have a number of exhibits, including, flipping to 1786, the board meeting of CrowdShout Limited. This is the very first board meeting where the directors here in the Isle of Man at Integrated Capabilities held a board meeting to approve the purchase of the website. You'll see Section B has a number of documents that are said to be executed. Section D on page 1787 is the consulting agreement that I referred to, Your Honor, where the company says we're going to execute this between Westmark Capital and the company, dated August 10th as well. And then we get to the promissory notes, and subsection E1 is that very promissory note that I'm referring to with Richard Katz. Now, while the dispute is ultimately about who controls the claimants, there's really also a big dispute over the dissipation of the revenues of CrowdShout Limited. So this website was generating over $200,000 of revenue when it was acquired over 4 years ago. Since that time, there has been millions of dollars flow into the bank account in the name of the directors of CrowdShout Limited, and that's exactly how the bank account is referenced with Barclays Bank here in the Isle of Man. So all of these advertising revenues went to an account in the Isle of Man at all times of which was controlled by Mr. Perks and Mr. Cannell. I never had access to or control over those funds. but as a United States business person that was entering into a business relationship with integrated capabilities, putting my full faith and trust in them, one of the most important documents is actually this Exhibit A, which is 1790, the annual operating budget. This says how all of that money is going to be distributed. As it turns out, and as the bank statements show, the money was distributed far, far differently than what everyone agreed to. And so Mr. Katz, who is the ultimate beneficial owner of the Richard B. Katz family number 2, who was also my attorney at the time, who was also undisputably the attorney for Crowd Shout Limited in Kansas and Crowd Shout Holdings at the same time, drafted this very language because any disputes arising out of or in connection with this transaction he would ultimately want to have adjudicated in his backyard.
Mentions the Isle of Man, doesn't it, somewhere?
It does. It says the non-exclusive jurisdiction of Kansas or the Isle of Man. That is correct, Your Honor. It also says that the
selected in the sole discretion of the lender being
Richard B. Katz family number 2, and Richard Katz is the ultimate beneficial owner. And let me just go down that path just a little for Your Honor. Richard Katz and his law firm, the Katz Law Firm, are defendants in a court action pending in Kansas. This action is newly filed. It was filed in September 15th of this year, along with other defendants include Integrated Capabilities and Mr. Perks individually. It's a 10-count petition, which includes fraud, aiding and abetting, civil conspiracy, legal malpractice, so on. Mr. Katz has made responsive pleadings in that case. I assert, and I don't think Mr. Katz disagrees, that he has chosen Kansas as the forum to determine these disputes, all arising out of these documents that were all signed at the same time as a part of the purchase of the website. But for the purchase of the website, there would not be a Crowd Shout Limited. That's why it was formed, as well as Crowd Shout Holdings. Indeed, the Kansas petition is a 7-count petition. Count 4 is for an accounting of Crowd Shout Limited's revenues. And so when you consider how an accounting would happen, you've got the bank statements, and you compare that against the operating budgets, and on page 1791, equally important, Exhibit B, the distribution of funds agreement. Again, specifying how the money is going to be distributed, and to who, how frequently. As the business person running this deal, these two documents are the most important documents in the whole transaction. How the money, all this money that ICAP has total control over, how that money is going to be spent. Even the operating budget on page 1790 has a line item for professional services. That is ICAP, Integrated Capabilities. That represents their monthly fee for acting as directors and nominee shareholders for the companies. Certainly, I'm sorry, Your Honor, and if I'm talking too fast, just tell me to slow down. Yes, page 1790, going back to the operating budget. There's a line item for professional fees. Below it, you'll even see the line item for Katz Law Firm legal fees. The first one is the hosting fees, which is hosting fees for the website that's acquired. The management fees, that's the consulting agreement. Those are the fees. That $40,000, and I know it's a little bit difficult to read, but that $40,000, if you were to go to the consulting agreement, is exactly in line with what the consulting agreement says that Westmark Capital would be paid. And so I submit that both CrowdShout and CrowdShout Holdings have already agreed to the jurisdiction of Kansas because the lender has chosen that forum, has filed responsive pleadings in that forum as recent as this week, and clearly by the language within the on page 1783, it makes it real clear on section 3 that they waive any objection it may have now or hereafter have as to the venue of any such action or proceeding brought in such court, or that such court is an inconvenient forum. So,
but this all relates to basically a loan agreement, doesn't it? A promissory note. So CrowdShout borrowed a lot of money from someone, and from Mr. Katz's foundation. And if there was any issue about the enforcement of that loan, this clause governs that, doesn't it?
yes, and I believe it extends.
How can it be? You say it extends, does it, to the any issues about the ownership of CrowdShout Limited?
I think it's.
CrowdShout Limited.
Sorry, Your Honor.
So it's very wide. It goes wider than the agreement, wider than the promissory note transaction.
Yeah, and I'm reading the language that says in connection with, and we have attached to the very note that we're talking about.
So there, where do we find that wording?
Certainly section 4, Your Honor. I'm sorry, it's not 4.
Sorry, I've lost the page.
Yes, I'm on page 1783.
Thank you.
Yes.
I see. What you're saying is agrees that any legal proceedings
There you go, yes.
party to this agreement arising out of or in connection with this agreement may be brought in the foregoing cause.
Which the foregoing court being
Either
Kansas.
Either Kansas or the Isle of Man.
Correct.
Depending on
Yes.
the discretion of the lender.
Yes.
Okay.
A little more background here, Your Honor, may be helpful. So as I said, Richard Katz, who's a Kansas lawyer, was at this time acting as the attorney, the Kansas attorney for both the claimant companies, undisputed. The dispute over the ownership of the company started to boil, if you will, in late December of 2014. So we're 2 years down the road, roughly. There was a transaction, as this court may have read, the stock transfer agreement.
Yeah, that was in November, wasn't it?
November of 2014. You're absolutely right, Your Honor.
Right.
And so I'm jumping forward a little bit, but here's the key I'm wanting to make with the court, is that when this dispute started, a gentleman by the name of Eric Kraft entered into the picture, and you may have read that name. Mr. Kraft, at the time the website was bought, was an employee of the Katz law firm and Mr. Katz, who actually helped form this helped with the formation, so much so that he verified my identification to the Isle of Man government. But in 2014, whenever I became the controlling shareholder, whenever GCM Holdings became the controlling shareholder, he was no longer with the Katz firm. He became adverse to my interests and was the one that wanted to figure out a way to unwind my November stock transfer agreement. In doing so, Your Honor, here's the key I want to drive home. Mr. Kraft went to Mr. Katz and obtained the CrowdShout client file. So Mr. Katz has knowledge of these disputes going on in November, December of 2014. Undisputed. His name shows up in correspondence. There's a December 18th, 2014 letter that was sent by Mr. Kraft, who sent it to Kevin John Perks. And I'm going to pull the page number on that because that's a key document. But in that, he copies the Katz law firm and says, I understand that Gabriel is asserting that he is a director. while we understand he may be the majority shareholder. So they admit, Mr. Kraft admits to my stock transfer agreement. While he may be the controlling shareholder, we don't believe he's acting under the authority of the board of directors. And this is copied to the Katz Law Firm. The Katz Law Firm hands Mr. Kraft in January of 2015 the client file for CrowdShout Limited so Eric Kraft can initiate the Kansas proceedings, which occurs on the 23rd of January of last year. So Mr. Katz had knowledge, and so much so that he gave the CrowdShout Limited client file from his law firm to Mr. Kraft, Eric Kraft, in order for him to pursue legal claims against Gabriel Murphy personally and Westmark Capital. And so Mr. Katz knew that was the time for Mr. Katz to say, you know what, I think I want to take this fight to the Isle of Man. Indeed, I had retained advocate here in the Isle of Man to better understand how in the world Mr. Perks can continue to act as a director whenever there is a clear resignation letter, and we'll certainly get into that document here in just a bit. But they had resigned, ICAP had resigned their services very shortly after I became the controlling shareholder. Now, I assert that Mr. Halsell really doesn't represent the claimants in this matter. I assert that the claimants in this matter are really defendants 1, 3, 4, and 7. No doubt, those defendants are the ones that are driving this court action. And they're the same people behind these companies are the ones that colluded to file the unauthorized claim in Kansas in the name of CrowdShout Limited. And again, that occurred 23rd of January 2015. As I mentioned, I had obtained local advocate, Mr. Go, and I apologize, I'm probably mispronouncing.
Mr. Goff. Yeah.
Goff, thank you. That won't be the last time I mispronunciate something, so I apologize to the court. Mr. Goff, who sent a demand letter to ICAP, effectively saying, I've got this resignation letter, what are you guys doing, acting like you're the directors?
Yes, I flagged that, so that's, anyway.
Yes. So I appreciate that the court is mindful of that. Certainly, all of the local advocates that I have spoken to are very shocked and confused as to how integrated capabilities can send a clear resignation, and I want to get into that now. So if we could.
Yes, I've seen those resignation. Yes, they seem clear on their face. I think Mr. Halsell's argument is that they were valid resignations, but they weren't sent to the right people.
Could you say that again? I'm sorry.
They weren't sent to the correct people.
That they were not?
They were not technically correct because they weren't sent to, I think, the company. Anyway, he
certainly
he refers to that in the notice of claim, and of course, when it comes to company law, one has to stick rigidly by what the Articles of Association and what the shareholders agreement say.
Certainly.
Okay.
Certainly. And if we could actually take a look at that, because I want to address the issue, the notion that it wasn't sent to the right people.
Yeah.
And we're talking about Exhibit D in file number 1, and I'll give you the page number.
Sorry to interrupt you again, but I mean, these are all issues which need to be dealt with in due course, don't they? I mean, there'll be arguments about this, no doubt. The issue is where the argument should be ventilated, whether it should be here or Kansas.
Right.
And I have to say, one's looking here at an Isle of Man company and a Maltese company. The argument, so Mr. Halsell will say, must surround either Isle of Man law and or Maltese law. What is the connection with Kansas in relation to the interpretation of the shareholders agreement and these letters of resignation. I mean, this all happened in the Isle of Man, maybe subject to Maltese law, but where's the Kansas element in this particular issue? I mean, it sounds like there's wider issues, but
as it relates
technical company law issue.
Yeah, as it relates to interpretation of the shareholders agreement of CrowdShop Holdings, which you're absolutely right, Your Honor, that is the heart of the dispute, and ultimately what has to be determined is an interpretation of that contract.
I think you said that somewhere. You said that's the nub of the dispute, the crux of the dispute.
Yes,
yeah.
Yes, and it's undisputed that shareholders agreement is subject to Malta law.
Yeah.
The shareholders agreement was born out of Kansas, so to get to the connection between it. But I'll tell you this, given there was a ruling, I was in court in Malta on Monday, and Justice McKeon issued a 53-page opinion. I want to be very careful not to misinterpret that opinion. It's in Maltese. I don't speak or read Maltese. I do have...
It's been translated. Mr. Holsall's arranged for translation. Have you received that?
I have not.
Oh, right, okay. I got that yesterday. Oh, that's a bit strange.
It was emailed to Mr. Murphy, sir, and it was hand-delivered to his address for service in Victoria Street.
Yeah, this is actually attached to this witness statement, isn't it? It sounds like you received this, Mr. Murphy. Witness statement yesterday.
I'm not aware of anything from yesterday.
This is Mr. Holsall's witness statement. Basically, it consists of a couple of emails that has gone between you and him.
Yes.
And also, it attaches the Maltese judgment in Maltese, and also, I think in fairness, it's not an official translation, but it's a translation anyway, of at least part of the judgment. Does he the whole of it, Mr. Holsall, but most of it anyway?
Yes, I believe that's correct. So it's been provided by Maltese lawyers, sir.
Okay. Well, you might want to have a look at that. So.
Okay. But in that order, my understanding, and obviously Your Honor has an English translated version, is that the Malta court wants to take full control over the heart of the issue, that is, who controls CrowdShop Holdings, which is a Maltese company.
Well,
the interpretation of the contract subject to Malta law.
That may be a very good thing.
And that makes sense to me.
Yeah.
GCM Holdings is inclined to agree with the Malta court in their opinion.
I was told that Malta was not a suitable forum because of the huge delays in their court system. I mean, having seen this
Yes.
impressive judgment, I don't know. I mean, they seem to do
I'll
things
tell
pretty
you that
quickly. They've actually done things quicker than we have. But
I believe the Malta court will move very quickly. Yes, Mr. Halsall, I think, represented that there's a backlog of approximately 8 years.
yeah, that's right.
And that's simply not true. That's just not the case. The Court of Appeals in Malta does have a decent backlog. But this issue, Justice McKeon, I'm told, moves very quickly. I've been in front of him twice. The next court sitting is 4 weeks away. And my understanding is it's on the plaintiffs in that action, which is defendant 3 and 7. Make sure I'm referring to. So in Malta, we have the claimants are Digital Tech and Integrated Capabilities, which are, yes, defendants 3 and 7. It is on them to now show evidence as to why this stock transfer is not valid. And so I believe that case will move forward quickly. It's my view that Malta is actually the best forum to determine who controls CrowdShop Holdings.
Well, that's a Maltese company, yeah.
Yes. And in doing so, by making that determination, everything else falls into place thereafter. Because I say it's undisputed, but maybe it is, that the sole shareholder of CrowdShop Limited is CrowdShop Holdings.
Well, I think that is contested, isn't it? It said that the sole shareholder of...
They have this, the Nova Scotia,
yeah, that's right.
which is defendant 1, is sandwiched in between these two companies.
But the ultimate beneficial owner of CrowdShop Limited is CrowdShop Holdings Limited.
Yes, the other way around, I think, Your Honor, but yes.
But from the legal point of view, Nova Scotia Limited is the sole shareholder of CrowdShop Limited.
To the extent that the directors, the integrated capabilities, are still in their positions. My position is based off of Exhibit D to my application to stay, those services, and nominee shareholders is specifically named within all of the services they're resigning from in that official letter from December 8th of 2014. And we can take a look at it if it pleases the court. It's in File 1, number page 28. So Your Honor will note that this letter is addressed to the directors of CrowdShout Limited and CrowdShout Holdings Limited. And it's the third paragraph down, citing Isle of Man law, giving the 8 weeks required notice. Indeed, Mr. Perks went so far as to file a Form IM06 with the Isle of Man Company Registry, notifying them that they are resigning as the registered agent of CrowdShout Limited on the 17th of November.
Yeah, that's notice of intention to resign as the company's registered agent, yes. Right. But so far as the resignation of the directors is concerned, that was done separately, was it?
Say that again, I'm sorry, Your Honor.
So far as the resignation of the directors was concerned, was that done in another document?
Yeah, so look at in the same document you're looking at, the second paragraph, last sentence, and I'll read it for the last two sentences. For the avoidance of doubt, it's the whole paragraph. In accordance with Clause 9.1 of our terms and conditions, we're giving 30 days written notice to terminate our agreement to provide administrative services from the date of this letter. This includes all other services provided to the companies will cease on the 8th of January, which includes the directors, registered office, nominee shareholders, all administration, bookkeeping, accounting, VAT, etc. So, to me, this is very clear that they resigned. As a result of this letter, as well as the email resignations from Mr. Perks that are the exhibits B and C to the application, and at the advice of Mr. Goff, I ended up having, I'm sorry, I take that back. I did not engage Mr. Goff at the time I had my shareholders meeting, but I ultimately had a shareholders meeting in November and elected Rogina Murphy and myself as the directors of both the claimant companies. So let me talk a little about going to the heart of the application to stay. Historically, my understanding is this court has looked to, and I know I'm going to mispronunciate this case, I say Spalida, as long as you understand.
I understand, yeah.
Yes. And I refer the court to page 16, paragraph 53, where I go through an examination of the considerations in Spalida and apply that to this very case.
Yeah.
In terms of order of the proceedings, we have Kansas first. Mr. Hossel's going to no doubt say that Kansas has to do with getting an injunction against Gabe Murphy because he was doing bad things. But if you look at the petition, there's no doubt that they sought declaratory relief as to the directors of CrowdShout Limited when they filed their Kansas petition. And we can take a look at that. Mr. Hossel's certainly right that the cases are not identical. There's subject matters being adjudicated in the Kansas action which are not present here, namely the consulting agreement.
Yeah.
But as a part of that action, they asked for a number of relief from the court, including declaratory judgment as to the directors of Crowd Shout Limited.
Yeah.
And Your Honor may have read that already.
Yeah,
So
I'm not sure I have seen the actual document. If you have a reference to that, that would be
I can
helpful.
certainly, if Your Honor will flip
It may be
to.
accepted by Mr. Halsall, actually. Is that right, Mr. Halsall? There is reference somewhere in the document to the Kansas proceedings to seeking declaratory relief as to the directors of Crowd Shout.
Yes, I understand that's an application put on by Mr. Murphy's side. Or being progressed.
Oh, right. Well, that needs to be sorted out.
No,
We've had a look at the document.
Certainly, it's page 118. And Mr. Halsall is absolutely right. I did later, in my answer and counterclaims, seek declaratory relief for Crowd Shout Holdings Limited as well.
Right.
But if you look at paragraph 58,
Yeah.
wherefore, and it's number A, Crowd Shout is properly governed by its current board of directors. In fact, Judge Gurney, who is the judge in Kansas, specifically cited in his order from 2nd of September of last year, he specifically cited that it was Crowd Shout Limited who first asked for declaratory relief as to the directors of this company. And I don't want to continue to flip around on documents, but it's certainly there in that order from the Kansas court. As Mr. Halsall referenced, it is true that I individually sought declaratory relief for the validity of the share transfer agreement, as well as the directors of Crowd Shout, the directors and the shareholders of Crowd Shout Holdings, in my answer and counterclaims, which was filed on the 3rd of March of 2015. In early May of 2015, GCM Holdings, which was not an original party to the Kansas action, filed a motion to intervene in the Kansas case. And of course, its argument to the court was GCM Holdings is the controlling shareholder of the plaintiff's parent in that action. And that action was brought without any authorization from the actual directors or the controlling shareholder, GCM. Ultimately, the Kansas court granted GCM's request to be joined as a party, and that was the order from the 2nd of September that I've referred to. It's important to understand that this court action was filed purely to be used as a tool by the Kansas court, and the HC1 claim form was actually Exhibit A to Mr. Kraft, who was the Kansas counsel for Crowd Shout Holdings at the time, to their motion in opposition of GCM Holdings' motion to intervene. I'm sorry, and that's not a motion. It was a filing that they made opposing GCM intervening in Kansas. I think in the pleadings that the claimants have filed, they specifically mention in their claim form that they are opposing that application by GCM Holdings. And so that's how this case came to be born, is through the intervention of GCM Holdings in the Kansas court action.
So we've got 3 courts in different parts of the world, all having this claim or claims about the ownership of Crowd Shout and Crowd Shout Holdings Limited. It's in 3 different jurisdictions, so the question is, which is the most appropriate one? You've just said that Malta is the most appropriate one to deal with Crowd Shout Holdings Limited.
Yes, and I think that that ultimately will decide Crowd Shout Limited as a result. Yes. And I'm inclined to acquiesce to putting a stay on the Kansas case even. GCM Holdings will do that. As it relates only to the declaratory relief for the validity of the stock transfer agreement. I would agree to stay that action and stand down to Malta if this court were inclined to stay its action as well.
And as a matter of interest, has the Maltese court given any sort of further directions as to when it could deal with this case? I mean, it's given this interesting judgment, but I think it basically, or you haven't seen the translation, but it basically says, well, we want to get on with this case, and I wonder when it's going to actually deal with it. Anyway, maybe Mr. Hunter will be able to tell me.
Yeah, my understanding is that the Malta, the court, I had originally requested a stay of that action. That was denied on the grounds that these are Maltese companies that are in the fight over interpretation of a contract subject to Malta law.
Yeah.
So I respect that decision. It makes sense to me. Yeah. So I believe that for the issue that's at the crux of the controversy is an issue to be decided in the Malta court. The next court hearing, my understanding of the order is that Judge McKeon now wants to get into the merits, and it's on the other side to show why that stock transfer agreement is not valid. Another reason why the Malta court really makes the most sense for determination of this particular issue is that the company registry is a defendant in the Malta claim. So it makes it real easy for the court to make the determination and then order the company registry to either register my shares or not. You can be assured that whether I get a favorable judgment or my opponents get a favorable judgment in the Isle of Man or in Kansas, those parties are going to try to domesticate that judgment in Malta and have it enforced there. So ultimately, it's going to end up in the courts of Malta one way or another. And so it just seems to make the most sense to have the Malta court determine who controls CrowdShout Holdings.
And that in turn, you say, will resolve CrowdShout Limited.
Right, and it'll resolve the ancillary issues which go to the dissipation of the company's revenues. You have to understand, by keeping me in a majority shareholder position, the real ulterior motive here is to keep myself from pursuing claims that I believe CrowdShout Limited has against various parties for the wrongful dissipation of the revenues of this company. Your Honor may have read a number of places in the pleadings filed by Mr. Hossel that my actions are, quote unquote, fraudulent and abusive. I take extreme exception to that, and such is analogous to the pot calling the kettle black. When a company clearly resigns over and over again, any reasonable person, I think, would take the actions that I did. I certainly did file the IM-12 with Lindsay Dunn at the company registry on May 9th of this year. I did so at the urging of both my Kansas and Malta counsel. Included with that registration was both the resignation letter from Mr. Perks, as well as his emails resigning from November, as well as the emergency shareholder meeting that I ended up having as a result of their written resignations. So I don't think there's anything at all fraudulent and abusive. And I know I'm getting a little bit off of the merits of the stay, so I apologize, but there is some interconnectedness between these issues. Going back to the merits of the stay and a comparison of Spilita versus the issues before the court, paragraph 53 on page 16 walks the court through that. We've got CrowdShout Limited, both a party in Kansas and here, in this case.
Sorry, I'm just catching up with you now.
Yes, I'm sorry, take your time.
The page
16 on file 1.
Okay, thank
and I went off on a tangent there based off of, I was making the point that the same relief as to the directors of CrowdShot Limited were first pled in Kansas by CrowdShot Limited's own attorneys. And as you may recall, it's Mr. Perks is the affiant in the Kansas court action. Mr. Perks testified in his deposition, which I attended on the 12th of August of last year, that he did in fact resign from CrowdShot Holdings. I brought my laptop. I can play the videotape deposition, that portion, to the court if it so chooses.
We've got the transcript.
We have the transcript, yes. I included a full transcript because I didn't want to just take a portion of it. I believe you have to look at the deposition in its totality, in all fairness. But certainly he admits to resigning.
Well, it looks like he intended to resign. It's now said, I think, that he didn't do it properly.
Well, I think what you're going to hear is, well, Your Honor, we unresigned, actually. Mr. Murphy received a letter from us on December 18th. So this Exhibit D letter is dated December 8th. 10 days later, I receive a letter saying, quote, based off of information that we've come to learn, we feel it's in the owner's best interest that we retain our positions as directors, and therefore we're going to proceed accordingly.
So what do you say happened in the interim period? They did, it looked like they resigned, then they changed their mind. So what happened?
What happened?
What's going on?
Very good question. Two things happened. One, Eric Kraft had contacted them saying Gabriel Murphy is making claims based off of that belong to CrowdShot Limited, going to that December letter that I referred to. Number one. So they realized Gabe's bringing claims against people in Kansas, and they probably didn't like that. The second thing is Digital's attorney in Florida sent a letter on December 10th, or December 9th, excuse me. It wasn't received. It was dated December 9th, sent via FedEx. I can't represent to the court when it was actually received by ICAP, but based off of a look at the timeline, it would make sense that ICAP didn't receive that until after December 10th, when they had sent the resignation is dated December 8th, so it was dated one day later. And this is a key letter. This is a letter that says, we need to have a shareholders meeting without Gabriel Murphy being present. He has asserted claims against Digital, which I had, that we need to have a shareholders meeting and unwind this notice of indemnification claim. And Your Honor may have read a little about that. I'm sorry?
Notice of identification.
Indemnification. Excuse me. Yes, that could have been my bad. Yes. This goes back to the transaction, the purchase of the website for $3 million. The asset purchase agreement had a number of representations made by the seller, Digital. So Digital Tech is the seller in the asset purchase agreement from August of 2012.
Right.
Okay? They made a number of representations, and there is a provision within the asset purchase agreement where the company can seek indemnification and hold back part of that purchase price, specifically $400,000. Notice had to be given to Digital. The time frame for any sort of dispute was 27 months from the closing date, which if you do the math, it works out to November 20th, 2014. They received their notice of indemnification claim the day before, and about a week before that, I became the controlling shareholder. If we were to look at the notice of indemnification claim, Mr. Perks and the directors of ICAP knew of this and endorsed it. And so Digital gets the notice of indemnification claim, huddles up, and says, how are we going to deal with this? At the same time, Eric Kraft is dealing with me asserting claims on behalf of CrowdShot Limited against attorneys in Kansas. Those two events all come together at the same time. And that is the reason why they decided to unresign, if you will, and remain in their position to keep me as the director of CrowdShout Limited from pursuing meritorious claims against parties that had received money from CrowdShout when it had absolutely no contractual relationship with the company.
So you have Digital Tech were the seller of the website?
That is absolutely correct, Your Honor. They were yes, Mr. Conley and Mr. Thomas, are the two beneficial owners of that company, who were and they're like me, tech entrepreneurs. They created the website in 2010. It was at all times prior to the APA, was owned by Digital Tech. Yes, sir.
Okay.
You've got it.
So that's the sort of background in the so-called change of mind about the resignation.
That's right. We have those two key elements coming together at the same time in mid-December that led to ICAP reversing its position and thereafter saying, not only did we not resign, we don't consider this to be a valid stock transfer when they themselves signed it. And let's just take a moment, if we can, and look at that stock transfer agreement. It's Exhibit A to the application to stay, which is on page 19. And obviously this is the key document to determine whether this is valid or not.
So this is the transfer between Hearn Holdings and GCM.
Correct.
So this makes you effectively GCM the majority shareholder in CrowdShout Limited or CrowdShout Holdings?
CrowdShout Holdings, Your
CrowdShout
Honor.
Holdings.
Yes, sir.
Yeah.
That is correct. And the math is CrowdShout Holdings is 20,000 shares outstanding. Hearn Holding owns 7,500 when the company was formed. GCM Holding owns 6,500 when the company was formed, and Digital owns 6,000. Part of the consideration in that $3 million was they keep part of this new company. They are an owner of the new company that owns the website. And so by virtue of this stock transfer agreement, GCM Holdings ended up holding 14,000 shares. Even the Malta court, in their order from the 2nd of September, the justice says in the order that this share transfer has taken place. It has occurred. And if it pleases the court, I can show you it's within the bundle. I'll have to dig to find it. I've read it several times.
So CrowdShout Holdings Limited, that's the Maltese court, of course. Yes. Maltese company.
Yes.
So far as CrowdShout Limited, the Isle of Man company is concerned, as I understand it, there was the change of shareholders was not registered in the register of members. I think so far as Isle of Man law is concerned, that's the crucial document. It's the register of members is the crucial document. The
register of the directors?
Register of members, the shareholders.
The shareholders,
yeah.
Right.
Yeah.
And nothing had changed there.
There was no alteration made to that register, as I understand it.
That is correct. That is my understanding as well. There's not been the only thing that Mr. Perks or ICAP filed in relation to CrowdShout was the form IMO6, the change of registered agent, notice of intent to resign as registered agent, in November of 14.
Yeah. So that was actually filed at the company's registry?
Yes, sir. Pursuant to the stock transfer agreement, it says that these shares will transfer upon notice of GCM, but in any case no later than December 31st, 2014. So on January 1st of 15, I emailed Mr. Perks and tell him to register the shares, and from there the dispute occurs as to whether or not Digital had the right to know and or participate in this stock transfer agreement.
Yes, because there was a preemption clause basically in the shareholders agreement. It's a very common thing. If you want to transfer your shares, you've got to offer them to the other shareholders first.
Section 2 is what you're referring to, Your Honor. Absolutely.
Exactly.
There are conflicting sections within the shareholders agreement. Section 14 is diametric to Section 2.
Well, yes, and it seems to be suggested. I'm not sure that this was added in some way at some later date. I haven't actually seen the share. Is the shareholders agreement in here somewhere?
We would think within 1,800 documents, I might have had that as an exhibit.
But it sounds like it's sort of been interposed for some reason.
I can speak to that because I was the author of that document.
Okay.
Like many of these documents from August of 2012, which was when this document came to be, there were a number of iterations done. There was negotiation as to the language. Section 14 was added into the agreement and agreed to by Digital. If you look at previous versions of the shareholders agreement, there were other shareholders that were contemplated to be shareholders of CrowdShot Holdings. Initially, there were 5. There were actually going to be 5 shareholders in CrowdShot Holdings. But as that document and as the deal ripened, ultimately there were only 3 shareholders. But that language certainly wasn't added secretively or under the table. The other side, being Digital, and their attorneys had a red line version of that, saw the added language, and acquiesced to it.
But it creates a conflict, doesn't it, in the document itself, which is...
That is right.
A recipe for litigation, isn't it?
I would say that's well put, Your Honor. It is a recipe for litigation, as we now know. And so interpretation of that contract that conflicts with itself is the issue at hand.
And just so I'm clear on this, that's CrowdShot Holdings Limited, which is a Maltese company.
That is correct.
So obviously the court to deal with that, one would imagine, would be the court in Malta. Well, the bank court could deal with it, I suppose.
Right.
It would have to call evidence of Maltese law. We'd have to have experts on Maltese law coming here.
Right.
Which is, I suppose, not ideal, but there we are. Could be.
Seems very inconvenient whenever Mr. Perks and his company went to Malta in the third instance and filed a claim there. We've already got the claim going. Seems like it's the most appropriate jurisdiction to deal with that particular issue.
Yeah. Right.
So in going back to page number 16, we've got the same party, CrowdShot Limited, being a party in this action and in Kansas. We've got the same declaratory relief sought, and it was Mr. Perks himself who brought that court action, not me. I've not brought any of these court actions. Instead, I'm trying to simply defend the rights of GCM Holdings from what I believe to be fraudulent activity instigated by attorneys in Kansas. Your Honor may have read the name James Neild within these pleadings. Mr. Neild was my attorney, who is also an attorney at the Katz Law Firm. Until his deposition in August of 2015, it was unknown that Mr. Neild didn't even have a law license, nor has he ever had a law license in Kansas. But yet he was advising me and CrowdShot Holdings in August of 2012 on the purchase of the website. Mr. Neild was sanctioned by the Oklahoma Supreme Court when he practiced in Oklahoma. I'm going to quote some of the things that the unanimous opinion says about Mr. Neild, that he has engaged in conduct involving dishonesty, brought shame upon the legal profession. He falsified travel documents and submitted them to his employer for compensation when there was never these expenses borne. And of course, those expenses would have been paid ultimately by the clients of the law firm. Mr. Neal simply did exactly what he had done before. I was simply the next victim. Mr. Neal undisputably received $185,000 in change from CrowdShout Limited. Undisputed. He admits in his deposition that there was never a contractual relationship between CrowdShout Limited and his company that received this money, called Boxa. I say his company. I assert actually I'm the ultimate beneficial owner of this Kansas entity. There are very complex issues in Kansas between Mr. Neal, Mr. Lagerstrom, who is the beneficial owner of Hearn, Defendant 3, and the ultimate beneficial owners of Digital, all of whom are parties to the newest court action that I referred to earlier today, that was filed in September of this year, alleging fraud, civil conspiracy, aiding and abetting, etc. So there's a lot of nefarious financial transactions that have occurred to the detriment of CrowdShout that ultimately is to the financial detriment of GCM Holdings. Westmark Capital undoubtedly had a consulting agreement. It had the right to receive these funds. But in mid-2013, those funds stopped flowing to Westmark and for some reason started flowing to Mr. Neal. And so my point is that there are a lot of issues relating to CrowdShout that involve many people in Kansas. When you look at who's really involved locally in this action, you've got at most 3 people, all of which are directors of integrated capabilities. Mr. Perks, Mr. Cannell, and Mr. Perry. It's my understanding, and I know I'm getting a little bit off of the stay application, that in an ex parte hearing, an advocate has to divulge all of the facts that it knows related to the issue at hand. And I'm going to the injunction a bit here. You know, I'm shocked that Mr. Hossel didn't inform Deemster Goldring that, you know, Integrated Capabilities did tell Gabe Murphy that they resigned. You know, that was never put in front of the Deemster. And obviously Deemster Goldring didn't have a command of these facts. He probably had not read my application to stay. He was charged with whether or not to grant that injunction. In his order, he says it seems that there's been abusive action on behalf of Murphy, but he didn't have the resignation letter. And so,
well, I don't know. I mean, one would have to look at that, but the particulars of claim, which I think probably Deemster Goldring did see, and certainly I have seen,
yes,
do set out the fact that there was an apparent resignation. I mean, so the key pleading in the case does set that out.
I need to look at that, but okay. I don't, okay.
I think I'm right.
That may be, that, yeah, I don't want to say you're wrong,
I don't want
certainly.
to mislead you in any way, but I think that's right.
I'm going to try to find the claim form.
Claim. I think it's in the first file.
I think it's in bundle 2 at 383, sir.
Thank you very much. Bundle 233. I'm on 395. I see the reference to the board meeting
2 and 403. And it refers there to the assertion that
Yes.
the CSL directors and the CSL Holdings directors resigned on the 17th of November, as to which it then sets out why, I think, those resignations were not in fact valid.
Understood. Fair point. Yes. So, again, going back to the comparison of Spelida, there could be no question that Malta is not an adequate forum, nor a fair and just forum. It was a forum that my adversaries chose. There's no potential prejudice in either forum. Again, these are forums they chose themselves. Convenience of the parties would clearly point to Kansas. All of the ultimate beneficial owners of the companies fighting are citizens of the United States, all of which either live in Kansas or Florida.
So the real dispute, the real dispute in this matter is about the beneficial owners. The people behind all these companies are actually residents of the USA.
That's right. Now, in all fairness, Integrated Capabilities Malta Limited is a key player in this. They're not a shareholder, and their directors would be certainly witnesses, but Mr. Perks, being the main witness, has already been deposed. And so there's very little evidence that would be pursued in these proceedings, maybe the testimony of Mr. Cannell. But ultimately, when you look at where the parties reside, they're all in the United States. Furthermore, I don't think this court has neither subject matter jurisdiction nor personal jurisdiction over a number of the parties. And again, I assert that Crowdshot Holdings Limited is really not the company that's one of the claimants. Mr. Hossels just filed a lawsuit purporting to be the director of, or purporting to be the advocate for that company. Nova Scotia and Crowdshot Limited are the two companies that are domiciled here in the Isle of Man in this action. But all other entities are either U.S. individuals or Maltese companies. And I'm not sure that this court would have jurisdiction over those persons or companies. What seems clear to me is Malta being the most appropriate for the crux of the controversy, but certainly Kansas is more appropriate for a number of the ancillary legal issues that are presently being adjudicated there, such as the validity of such as the dispute with Westmark Capital and myself. It doesn't occur to me that the Isle of Man is the proper jurisdiction for these claims. In one of the pleadings in Malta, and I'll have to look this up, ICAP and Digital have effectively acquiesced to the fact that, well, we don't think the Isle of Man may be the best forum, but they're certainly able to determine these things, as Your Honor suggested. It could interpret Malta law. It could do all of those things. And this was in the application they filed initially in Malta. They basically said, we don't think the Isle of Man is necessarily the best forum. I think the parties really agree that, especially in light of the most recent Malta court opinion, that the actions certainly within this, the relief sought within the HC1 claim form are issues for Malta to deal with. And if this court were inclined to enter an order to that effect, certainly GCM Holdings would agree with that. And to have that particular issue adjudicated only in Malta, and to have this court in Kansas stand down as to any declaration to the directors and shareholders, which all go to the validity of the share transfer agreement. Something I should have told the court about the stock transfer agreement, and I certainly apologize for not having that as an exhibit. You would think in all the filings that I made, I would have had the shareholders agreement be an exhibit in one of these.
Have we got that, Mr. Halsall, in the documents?
Forgive me, I was just trying to struggle to remember if I read it in the bundle.
I haven't seen it.
I don't think so, and I've read the bundle several times overnight.
The relevant clauses are all set out. It's
yes.
There we are. But it's obviously it's a document governed by Maltese law.
Right.
It must be.
And Section 15 is a key portion of the shareholders agreement because it says the owner of 2/3 of the company's shares, which if my share transfer agreement is valid, I have 70%.
Yeah.
So if it says any owner of 2/3, a vote of 2/3 can elect, retain, and remove the directors at will.
Yeah.
And so certainly the validity of the share transfer agreement also goes to the issue of the rightful directors of these companies.
Right, it's now 11:35, Mr. Murphy. Do you think you're pretty much near the end of your submissions? I get the feeling you
As it relates to the application to stay, I think I am. I so appreciate the court listening and reading my application. I know it was very lengthy with a plethora of exhibits, so I'm most gracious that this court took the time to read it and listen to my arguments, and I will sit down and let Mr. Halsall make his points.
Indeed. Thank you very much.
Thank you.
Do you want to take a short break, Mr. Murphy?
I would, sir. It might, at this stage, I've just had someone bring up an extra copy of my witness statement from yesterday, which I'll hand to Mr. Murphy.
I think Mr. Murphy knows the gist of what the Malta court said. I think he was probably there at the time. So he knows that. But
I'll hand it to him anyway, because he's indicated he didn't receive it, but it was in the same email that went to the court, and as I said, it was delivered to the address for service at the same time.
I'm happy to carry on going, but if you want to take a comfort break or something...
A comfort break might assist, sir.
Okay, fine.
Thank you.
We'll take a short break now, just 5 minutes or so.
Thank you.
We'll resume. Mr. Halsall.
Thank you, sir. Yes, firstly, as indicated, the witness statement I produced yesterday was produced as soon as we had, that very day, the unofficial translation of the Maltese
Yes, that's very helpful. Thank you.
judgment. And it was emailed to Mr. Murphy at the same time as it was emailed to the court, so I don't know why he didn't receive it. And as I said, it was hand-delivered. And also, I'm not sure what happened on his side with regard to the bundles, and I'm grateful for him for cooperating with regard to what was to go in them, because obviously it was quite tricky. It's quite a lot had been.
Well, the bundles are excellent. I mean, they were very, very helpful. I mean, we couldn't possibly have dealt with the case without it all being properly.
Again, I am surprised that he only saw them yesterday, because I'm pretty sure there's an email to the court indicating they were being scanned through to him. And
it didn't seem to have caused any problems.
No, and apparently he's read them several times overnight as well. So that's very helpful. I'm grateful to him for spending the time on that. Now, there's been a number of allegations made this morning by Mr. Murphy to do with various parties that I don't represent, and I can't necessarily comment on a lot of these facts that have been raised today. But what I have to say is I don't want that to be held against my clients, CrowdChat and CrowdChat Holdings Limited, as if they are accepting that they are true, because I'm not in a position to comment on a number of the allegations made about various parties and individuals and their actions and alleged actions. What I can say is certainly any inappropriate conduct on behalf of the directors or former directors of my client companies is denied. Now, and also just to clarify, I think Mr. Murphy indicated that Mr. Perks was still purporting to be a director, but I can confirm he resigned earlier this year, and that's all on the record.
So Mr. Perks is out of the picture?
Mr. Perks is no longer works for ICAP, and he's not a director of either of those companies, and that was a resignation this year, sir. Now, as regards the issue raised this morning by Mr. Murphy with regard to the promissory note issue in the US, my understanding is that Mr. Murphy this week, I believe maybe Wednesday, but you can correct me if I'm wrong, had a hearing in Kansas where, for the second time, he attempted to get an injunction, an anti-suit injunction, I believe it's called, to prevent litigation being pursued outside of Kansas or outside of the United States. I understand that application, if that's the correct word, was rejected again, and that I instructed that the court indicated that any issues of forum to those other issues are not relevant. The promissory note isn't relevant to things like shareholders' agreements, and because obviously it's a completely separate document. With I can't really comment on the CATS litigation, other than to say it appears to me to be irrelevant to the issues. But I note that Mr. Murphy this morning appears to be saying that this case should be heard in Malta in preference to Kansas, which is something of a turnaround, considering we understand he was trying to get Malta to stay the case.
Well, it was said that Malta was completely unsuitable because of the huge delays in the court system, but the actual evidence that I've got before me now is that it's actually very efficient. Well, I'm not sure when this hearing took place. It actually, this judgment seemed to have been produced extremely quickly. And,
my instructions are that the Maltese courts are quick to deal with interlocutory matters, right. But then when you come to
first instance hearings, the trials.
Interlocutory matters. But when you get to contested hearings, things take an awful long time.
Right. Well, have you got any sort of evidence about that? Is there any idea as to when, for example, they could hear this substantive case? Because I mean, flick through the judgments, perhaps I just need to be clear what the judgment is about, which company it does concern. It must only be, I think, the Maltese company.
Yes, the Crowd Shout.
But obviously that has a knock-on effect in respect to the Isle of Man subsidiary, which is Crowd Shout Limited.
Yeah, Crowd Shout Limited, the Isle of Man company, the first claimant, is not party to those proceedings.
Right.
Now, those proceedings, and this is quite important, were brought after the Manx proceedings, and they were brought initially for interlocutory relief, urgent interlocutory relief, because it became known that Mr. Murphy had attempted to file papers with the Registrar of Companies, if that's the correct name, in Malta to change the registers there. So the Manx proceedings were issued in May 2015. Then subsequently, months later, in I think late August or September, the attempt to change the registers of Crowd Shout Holdings Limited was discovered, and an injunction obtained in Malta. And I recall that the translation of this week's judgment does refer to the fact that to get an injunction there, they had to have following substantive proceedings, which of course is not unusual in jurisdictions. And so the current proceedings were necessary because an injunction had been obtained in the first place. And that injunction is ongoing, I understand.
But anyway, these Maltese proceedings, the ruling's been given very promptly, it seems, and so what's the next stage? Have we got?
I'm informed, sir. I'm instructed that there will be a hearing, which will be some form of directions hearing late in November for the claimants to deal with issues of their evidence, but my understanding is they haven't been ordered to file it by then. I think my interpretation is that that's some form of directions hearing. But the instructions I have are that, and it's touched on by Mr. Cannell as to the length of time it takes, is that contested hearings take many months. I think there's a sensitivity.
They do
years.
They do anywhere, but we've got some firmer sort of information about that.
I've got no particular specific evidence over delays, and certainly when I've asked for the Maltese lawyers are somewhat hedgy over commenting on that point.
Somewhat, sorry.
Somewhat hedgy over commenting on the quickness of otherwise of the Maltese legal system. But the point is, of course, the main point is that the first claimant, Crown Shout Limited, is not a party to those proceedings. It's a Manx company with registered directors who are employees of an Isle of Man licensed corporate service provider. And Mr. Murphy, as you know, is saying that he is actually the director. And of course, he's not denied this, he filed forms IM4 and IM12 in the registry in May this year to amend the official public records to show that he was a director and that Appleby International in Apple Street was the registered agent and registered office. Now, that clearly was an abuse of the process because he isn't and didn't have the authority, and injunctions were given accordingly. And the whole action by Mr. Murphy in May confirms the need for proceedings in the Isle of Man, and certainly as regards Crown Shout Limited, the Isle of Man is the place to bring proceedings for injunctive relief and directions with regard to the directors and shareholders of a Manx company. And of course, there's similar arguments in Malta, and I do appreciate that. Now,
so far as Crown Shout Holdings Limited is concerned, Malta is prima facie the correct forum, or the better forum for that, isn't it?
well, certainly, without doubt, in our submission, in my submission, the Isle of Man is without doubt the forum for the issues as to regard to Crown Shout Limited. Malta, obviously, they can order the registrar of companies or the equivalent name to amend the register, and so whilst there are clear reasons why some issues may need to be dealt with in Malta, that doesn't prevent this case taking place here, because the first claimant, Crown Shout Limited, is a Manx company. Now, clearly it appears that there are two sets of proceedings with similar but not identical issues, and the ruling of Mr. Justice, if that's the correct phrase, McKinnon, this week on Monday is relevant to that. Now, we think that judgment is important because it shows how Mr. Murphy seeks to delay and confuse and mislead with the litigation. In that case, he was seeking effectively a stay of the Maltese proceedings, as there were Kansas and Max proceedings. So he's made quite a turnaround today. Now, those Maltese proceedings were brought by the beneficial owner of Crownshire Holdings Limited, the Maltese company, by Digital. As I said, Mr. Murphy had tried to file papers in the Maltese registry. Now, the court had indicated had a discretion to stay, but refused, and the court was quite clear that they are different cases. And at the top of page 57, in the translation,
Yeah.
The court highlighted that the case related to Crowdshout Holdings Limited and not Crowdshout, and this, of course, was deciding whether or not to stay the Maltese case. And the court did not consider the Kansas or Maltese cases form the same merit as the Maltese case.
This is paragraph 2, isn't it?
Paragraph 2, page 57.
This court starts by underlining, as it has already done in its decree of the 14th March 2015, that in substance the merit of this case is a disagreement between the shareholders of the defendant company Crowdshout Holdings Limited on a stock transfer agreement which took place with the shareholders of Crowdshout Holdings Limited. Therefore, the dispute in this case relates to the Crowdshout Holdings Limited. As already stated, the fact that the company Crowdshout Holdings Limited is the owner of CSL does not mean that the case relates to CSL, but therefore CSL has the interest required by law in order for it to be defended in these proceedings.
So CSL is not a party to that case.
No.
No.
Right.
And then, in the same sense, this court is not going to consider that the cases which were instituted in regard to the interests of CSL, that's the Isle of Man case, or Kansas case, form the same merit of the case which it has in front of it today. And at page 58, paragraphs 4 and 5, I'm sorry, the paragraphs aren't numbered, but there's a reference to it highlights how Mr. Murphy had breached the earlier Maltese order, so the September 2015 injunction, by instructing a US lawyer to represent Crownshout Holdings Limited in the US case. And the court found that this court therefore decides, this was at page 59, sorry, this court therefore decides that it should continue to hear the case in its merits in order to...
No, where's this?
Sorry, this is at the end of page 59. And the court said, although it agrees that the procedure in Kansas is going to deal with matters which is related in certain instances to the proceedings, it absolutely does not see that it should exercise the discretion, and that's to stay the case. And the court found it highlighted that Digital, the company there, is not part of the proceedings in Kansas, and the court decides that it should continue to hear the merits.
Well, that's very straightforward, isn't it? It's the last sentence, isn't it? This
Yes.
court decided it should continue to hear the case on its merits in order to decide on these issues clearly related to a company formed in Malta and regulated by Maltese law. Well, that makes a lot of sense, doesn't it?
Yes.
And then comments on the proceedings
And
in the Isle of
the
Man.
proceedings in the Isle of Man, and if we turn halfway down the page of page 60,
Yeah.
from the exposition of the merit of this procedure, so this is 1, 2, 3, 4, 5th paragraph down, from the exposition of the merit of this procedure in the Isle of Man, it results that there are various divergences between it and between the current procedure. Among them, Crownshout Holdings Limited is a plaintiff in the foreign procedure and a defendant in the current procedure. Digital and ICML are plaintiffs in the current procedure, while Crownshout Holdings Limited is the defendant in the current procedure. And the procedure in the Isle of Man relates to other parties and other claims, including also CSL, which is not a party to the current proceeding, so stressing that Crownshout Limited is not a party to the Maltese proceedings. And of course, the big point, which is dealt with in the last sentence on that page, is that the Maltese case was initiated after the decree was given issuing the warrant of prohibitory injunction. And in the light of the dispositions of law, this had to be followed by a case in order to remain valid. So we know that the Maltese injunction was obtained months after the Max proceedings were issued because of attempts to change the registry for Mr. Murphy in Malta. And so that's how those proceedings came into being. And they were brought by Digital, not by CrowdShout or CrowdShout Holdings Limited. They're brought by and on behalf of the beneficial owner of CrowdShout Holdings Limited. Digital, yes. And at page 64, the end of the first paragraph, the court was confirming it felt the Maltese court case should proceed despite proceedings in the Isle of Man and Kansas, and that the Maltese case shouldn't wait for the other proceedings. And it highlighted again differences in the procedure in Kansas, differences in the merits, differences in the parties, and as already stated, in the case of the proceeding in the Isle of Man, there are claims which are not included in that case and which can only be made and decided by the Maltese courts, which relate to the Registrar of Companies in Malta, because they're wanting orders there against the Maltese Companies Registry, which are not sought here in these proceedings. So I think that ruling is supportive of the opposition to the stay. And the big point is, CrowdShout Limited is not a party to those proceedings, and CrowdShout Limited seeks, and is entitled to seek, declarations as to its directors and shareholders being a Manx company from the Manx court, and that's the place to hear that. Now, it may be that this case has been complicated, but because of the issue in Malta as well. But that's a case brought about by the actions of Mr. Murphy in, we say, wrongfully filing in Malta, which led to an injunction, which led to proceedings brought by other parties in Malta.
Well, the fact is that those proceedings are ongoing in Malta and that they are proceeding, and the future of CrowdShout Holdings Limited, or its ownership anyway, is going to be dealt with in Malta.
Yes.
Right. So
Now that could have effect on it.
Logically, that should be the first case to be decided, shouldn't it? Then one could move on to deal with CrowdShout Limited. But it may be the wrong way round. Maybe I can deal with the case more quickly than the Maltese courts.
Yes.
I mean, I think it would have been helpful to have had some information about the timetable for this case.
Yes, I've asked for further detail, but all I can say is my understanding is that contested cases take a long time, like far in excess of most jurisdictions. Okay,
well, if that is
certainly there's absolutely no.
the case, then yes, well, it may well be that this court will have to deal with the issue. Having expert evidence from Malta, but I really need.
Well, Maltese company as well. I think it's clear from our papers. The Maltese law looks to English company law. They have their own. It's a similar position to the Isle of Man with regards to common law, and they look to English law like we do on occasion.
There's a lot of Maltese cases cited here, but they're about jurisdiction, aren't they? Rather
Yes, they are.
Company law.
Yeah.
So the company law has been imported to a large degree from England.
Yes.
So it would not be a difficult case for this court.
No,
yeah.
not at all. No.
Right.
And of course, foreign law is just a question of fact, and so it's, we would say, straightforward, and on occasions the questions of foreign law can actually be agreed. Now, I think a lot's been said as well by Mr. Murphy with regard to resignations, and I think Your Honour's clearly very familiar with the particulars of claim and the contention.
Well, I've read them. It's a peculiar set of circumstances.
It is.
On the face of it, these are very clear resignations, and most lay people reading would certainly think they resigned. That's it. And Mr. Murphy, one might say on the face of it, was entitled to act in the way he did. I don't know,
But the legal position is
the legal position is different. You say.
Yes, the legal position is quite clear with regard to the issue of directors and their position, and shareholders and their position. Whilst there may have been emails given, as indicated in the particular claim, they weren't sent to the companies. So the directors didn't resign to the companies they were directed.
What about that letter? Sorry, that letter that Mr. Murphy referred to, which was refers to the directors. It's from ICAP, I think, saying, well, we just resign entirely as registered agent and for the provision of directors.
They have to give notice. I think they have to give notice of, which I think they did, but notice of intention to resign as registered agent.
Yeah.
Then that wasn't carried through, I understand. So they have to give notice and then actually do it. So it's like a notice. You can then rescind the notice, and that effectively is what they say they did.
Well, they say that we're resigning as directors.
Yeah, but they didn't resign as directors. They didn't resign to the companies.
Isn't that notice is not sufficient?
No, and that's the point. And that's a point of relatively straightforward law, whether it's Manx law or Maltese law, we would say, and something that could quite simply be ruled on. So there'd be evidence from both sides, and then the court can rule on that. And obviously, as regards Crouch Out, the issue is Manx law. As regards Crouch Out Holdings Limited, the issue is Maltese law. So
there was this change of mind, it seems, that Mr. Murphy's given his perception of why there was a revocation of the intention to resign.
I can't give evidence as to why that actually happened.
There's nothing in the papers that really explain that from your side, is there?
No, I don't want to say for definite no. I don't recall it, but that was the decision that was made. So now. I think that's the main points that were raised by Mr. Murphy this morning dealt with. Now, we have filed and rely on a skeleton argument in opposition to the state application, which I know you're on a kindly read in advance. And also we have the particulars of claim, which are in the bundle.
Yeah.
The witness statement filed by myself in January, which is basically a chronology which deals with filings in the case, which we say is relevant to this issue of whether or not Mr. Murphy can challenge the jurisdiction.
Right. Well, that's we can look at that, can't we? But even if he did submit to the jurisdiction, he's still entitled to say, isn't he, that this is not the correct forum. You can say, well, there are various courts that have jurisdiction, but the correct forum for the dispute is actually another forum than this. So he can make that point, can't he?
He can raise it, and
it doesn't prevent him from applying
no, he can
on
argue
forum grounds,
no.
even if he accepted jurisdiction. I think you're
There's two different points, aren't there?
yeah. You say he submitted to the jurisdiction because he filed an acknowledgement of service, and he didn't apply under its Rule 4.16.
Yes, the challenge within the time period.
He hasn't done that.
I mean, no, and the case law on that we've included in the skeleton is clear that has to be done. So we've included reference to that. So we say he's already, GCM and Mr. Murphy have already submitted to the jurisdiction pursuant to the rules, or alternatively by conduct and the way they've dealt with the case, and we've gone into some detail on that. But if we're incorrect on that, we say Kansas is clearly not the most appropriate jurisdiction to resolve issues of the directorship and shareholding in a Manx company, or indeed a Maltese company. And Mr. Murphy appears to be going along with agreeing with that proposition this morning, and he's saying clearly it should be dealt with in Malta. And we say, well, it should be dealt with here, the case was brought here first. Both companies are party to the case here, CrowdStrike and CrowdStrike Holdings Limited. The Maltese case was brought after the event as a result of actions of Mr. Murphy. CrowdStrike is not a party to that case. And we say that the Isle of Man is clearly the appropriate forum. And we say that's unquestionably the case with regard to a Manx registered company operated by a Manx licensed fiduciary. Now, Your Honour, I don't propose to go into the detail of the submissions on submissions to the jurisdiction because they're all there. And
just one point you can just help me with, actually. I think what you're saying is that Mr. Murphy, GCM, filed the acknowledgement of service. I've got a note here that you say they sought an extension of time to file a defence. I just wanted to be clear where that application for an extension of time appears.
I believe it's exhibited to my witness statement, but I'd have to check the reference over lunch. If that's okay.
Well, perhaps you could.
Yeah.
Because I think that is an important point, because I think some of the case law certainly refers to that. You file an acknowledgement of service, you don't apply to set aside, you don't apply to contest the jurisdiction, and you then seek an extension of time. That looks very much like submitting to the jurisdiction. And
there was also an email where he indicated he was filing what he called an answer, which was a defence.
Okay.
But there was a link, and it's referred to in my witness statement and the exhibits. But neither the court nor my office could open it. And Mr. Murphy's position certainly isn't that he's filed an answer. I believe. I don't believe he's argued.
Okay, so he's.
But there was an email saying I'm filing, but neither the court I'm aware.
Could you take us to that maybe, or you check the reference?
Yes. I'll check both those over.
So I've got that clear. Okay. No, I think apart from that, I've got your submissions on submissions to the jurisdiction.
Yes.
They're all contained in your skeleton argument.
Yes. And the in the main are evidence in support of the opposition to the stay application is Mr. Cannell, but obviously it's linked in with those issues or in my witness statement, and also there's the witness statement of Mr. Cannell in support of the injunction too.
Yeah.
Now, there's a whole list in this, and I don't propose to waste time, but going through it all because it's all in the skeleton. So but there's a whole list of irregularities with regards to acknowledgement of service and issues with addresses and giving names of people purportedly providing registered, providing addresses for service, etc., which we say clearly were.
Well, I think we moved on from that, hopefully, but there seems to be a proper address now, isn't there?
Yes. Now, as regards the issue of forum in itself, we say that GCM, and when I say GCM, obviously it's been slightly complicated because the stay application, I think, was filed for GCM originally, but I understand that Mr. Murphy is appearing today in his personal capacity and arguing this application in his personal capacity and as a director of GCM.
Yeah. So
if I'm referring to GCM, generally I'm meaning Mr. Murphy.
Both.
Okay. Both, yes. So we say, and this is in paragraph 31 of our skeleton, that GCM must prove there's another forum that's clearly more appropriate than the Isle of Man. Now, it's not enough for them simply to show there's another jurisdiction where the case might proceed with equal convenience, and his strongest argument on that would be Malta. Now, as I've indicated in paragraph 32, GCM and Mr. Murphy argued the case should be stayed in favour of Kansas. He appears to have moved away from that. He's arguing today that clearly it should be Malta, despite only this week having had a hearing where he's been arguing that Maltese proceedings should be stayed. So we say he's just playing fast and loose with the rules and procedures, trying to delay, and he'll argue.
See how he would have any motive to delay. This is a matter that needs to be dealt with. Really.
Well, we say the whole history of this action.
Dragging on long enough, it needs to be.
Well, I can't.
Dealt with rapidly.
Yes.
I suppose most cases do. All cases need to really, but there are some which are more urgent than others. This strikes me as being one which needs to be sorted out very rapidly.
Yes. Well, as you may recall, we had initially the directions hearing on our application for judgment was listed for March, and then at Mr. Murphy's request it was put back to April. Then Appleby were instructed at the last minute appeared at that hearing, directions were set, and then there was a whole series of delays, which we say purely at the door of, from March, purely at the door of Mr. Murphy. Now, we've dealt with in some detail in paragraph 33 in our skeleton why Kansas is clearly not the appropriate forum, and I don't know to the extent I need to go into that in any detail in view of Mr. Murphy's submissions today. I mean, we say quite clearly the issues of who are the directors and shareholders of a Manx company. Appropriate forum is here. It's a natural forum for it. There's clearly an argument for Malta for Crouchhouse Holdings Limited, but I've explained the reasons why we say the whole thing should be dealt with here. But we say clearly.
There be delay, isn't it?
Yes.
About which I
Well,
have continuous evidence.
I concede there isn't any.
I think it was just an assertion in the application for service out of the jurisdiction that Malta had a long
Yes.
delay. But
Yes, there was. That's certainly the instructions I have.
there's nothing really to back that up, unfortunately.
The
Actually, just let me go back to that. There is reference in the application for service out of the jurisdiction to that to delay.
yes. Trying to remember what that is.
Yes, page 707. The bench advised these procedures in Malta. There is potential delay because the courts of Malta will be probably seized of the matter. Currently understood to be a backlog of cases nearly 8 years waiting for determination there. Yeah.
That was the instructions we had, sir. But getting a Maltese lawyer to complain about delays in their system isn't. We haven't succeeded in getting one to.
It's just a matter of setting out what the factual situation is, I think.
It is.
It's, okay.
Now, as regards the question of forum, we think, we say that the actual reality of the case law is the courts now look at a practical solution and see where, the case, can the case properly be dealt with here? Yes, we'd say it'd be very simple for dealing with any Maltese issues of law, and that dealt with here very easily. It's not like dealing with something, a completely different legal system.
What would happen though if this court makes a declaration as to the ownership of Crouchhouse Holdings Limited? I suppose if all the parties are present and the matter is dealt with on the merits, that would be, one would imagine, it would be automatically enforceable in Malta, but it would
But you see, the issues of comity would apply, and
so, yeah.
we'd say that the courts would take cognizance of that. Now, as I said, we dealt with in 33 with a whole list of reasons why Kansas isn't appropriate, and the following paragraphs. And we deal with Malta in 39 because we say there, while suggesting the commencement of these proceedings is evidence of a scattergun approach or forum shopping by the claimants, because that's something clearly Mr. Murphy is alleging. Mr. Murphy fails to acknowledge that those proceedings were commenced in response to his actions, mirroring, of course, the ones he recently took in the Isle of Man, in secretly filing notifications with the Maltese Companies Registry, by which he sought to alter the records of claimant 2, Crowdshout Holdings Limited. Certainly it is our case. I appreciate there isn't any specific evidence, but our case is that there are very substantial delays in contested cases at first instance in Malta. Now, we then say at 41, we indicate a whole list of what we say is abusive conduct by Mr. Murphy, which we say is in itself a good reason for refusing the application, which we say indicates it's in the interest of justice that there's issues raised by the claimant be determined by this court. And this links back into those issues that we've set out with regard to acknowledgement of service and so forth, and the filings. This false statement that I've dealt with in evidence about instructions being given for Dockery Quinn to be the address for service, and there's evidence exhibited this clearly wasn't the case. And of course, the big point is the filings he made in the Companies Registry in the Isle of Man. We say that clearly Crowdshout Limited is entitled to have proceedings ongoing in the Isle of Man to maintain the status quo with regard to the Register of Directors and Shareholders and Registered Office, pending the resolution.
I suppose, yes, your argument is that probably on balance, the injunction probably should stay in being, but it's entirely without prejudice, of course, to what the ultimate trial. And it may prove to be the case that the purported resignations were entirely valid, and Mr. Murphy should be instituted as the director of these two companies. But
and if that was the case, it would be very straightforward for Mr. Murphy to then get an order here rectifying the register here.
Of course.
Yeah.
But in the meantime, obviously, this company is just mired in litigation. I mean, nothing's. It's a matter of, I suppose, preserving what might be argued to be the status quo. It's quite difficult to say what the status quo is, but it doesn't. Maintaining the injunction does not really doesn't prejudice the trial, of course, in any way. It's not any indication of where the merits actually lie.
No, exactly. And we will
balance of convenience.
exactly. And frankly, we will be arguing this afternoon that the grant of that injunction was an obvious one, and in the circumstances, and clearly we'll be arguing that obviously that injunction should continue. And in fact, we would say that the email from Mr. Murphy of this week, which is in my witness statement of yesterday, evidences an ongoing risk that he will breach that injunction, and potentially that email could be seen as a breach of that injunction, because he's indicating that I shouldn't be representing Crouchshire Holdings Limited.
Well, that's that comes back to the essential dispute, which it just needs to be resolved quickly, doesn't it?
It does. Your Honour, unless there's anything specific that you want me to address you on.
No, I don't think so. Just those points about the steps which were taken. Yes, the seeking extra time to file a defence, and
yeah.
Has there been anything which amounts to a defence? Has that actually been filed? I'm not sure. I mean, there's obviously lots of material here which constitutes a defence, but I'm not sure if any single document has been filed.
I'll find it for you, Your Honour. And my recollection is there's an email from Mr. Murphy indicating he was filing, and Mr. Murphy quite often puts a link in to the document, and there was a link, and my understanding is the court couldn't open that link, and we couldn't open that link, and so we never received an answer. There was a covering email saying he was filing one.
Okay.
Thank you, Your Honour.
Thank you very much, Mr. Halsall. Mr. Murphy, you've got a little time. If you want to just make a short response, if you wish to, a reply maybe in sort of 10 or 15 minutes. If you want to say, if you don't, then that's fine. But if there is anything else you want to say on the issue of the stay and forum, then I'll listen to you for another 10 or 15 minutes, and then we'll probably break for lunch, I think.
Thank you. Yes, Your Honor, I would. And thank you for giving me the opportunity to, again, address the court on this. Clearly, this is a fluid situation. We have this new order from the court in Malta. And as Mr. Halsall said, it appears that I'm now changing my view as to what court has the proper jurisdiction and should hear the case. I believe it's clear that Malta should be handling the issue as it relates to Crowdshout Holdings. As it relates to Crowdshout Limited, again, it was Mr. Perks who first sought declaratory relief as to the directors of this Manx company in Kansas. Going to the Kansas petition, in fact, paragraph 7 states, and this is verified. This is a verified petition with Mr. Perks as the affiant, who purported to be the director at the time. It says, paragraph 7, I'm on page 110 on bundle 1.
Thank you very much.
I'll give you a moment to get there, Your Honor.
Yeah.
Yes, sir. Paragraph 7, Crowdshout is wholly owned by Crowdshout Holdings Limited, which is a company formed under the laws of the Republic of Malta. It's important to understand this notion that Nova Scotia belongs in the chain of ownership custody, if you will, is nonsense.
Well, yeah, I mean, as I understand it, Nova Scotia Limited is just an intermediary nominee for Crowdshout Holdings Limited.
Right.
So the reality is, yes, that, as it's said there, Crowdshout is wholly owned by Crowdshout Holdings Limited, as you would expect from the name. But yeah,
Nobody had heard.
Law, it's not. It is Nova Scotia Limited that actually owns Crowdshout Limited. Nova
Right.
Scotia Limited is a Manx company, isn't it? Yeah.
Yes, my point is that in the pleadings in Kansas, Nova Scotia was nowhere to be found, and the deposition of Mr. Perks, he asserts that the shareholder of Crowdshout is Crowdshout Holdings. So I suspect this Nova Scotia Limited company really came to be as a result of this Isle of Man petition being filed. Nova Scotia may have existed for however long and may be used as a nominee shareholder for a variety of integrated capabilities companies. But my point is that once Malta decides who controls Crowdshout, then Holdings, then we really know who controls Crowd Shout Limited. I
That's
think.
why I agree. I think that seems to be the logical order in which it can be done. But if Malta is going to take 8 years to decide this, I mean, that's not a very attractive proposition. I mean, do you have any view on this or any information about this?
I have an advocate in Malta, Dr. Joseph Potch, and I would submit to the court an affidavit from Dr. Potch. And it will say that it's rubbish that it takes 8 years to get this adjudicated. I certainly cannot represent to the court how long it's going to take. So I want to be careful about that.
So you were represented by a Maltese lawyer at the hearing the other day?
On Monday, yes, Your Honor. And we spoke about, I'm very much wanting to get this adjudicated as quickly as possible.
What's he told you about the next
Justice
step?
McKeon.
How long it's going to take?
Sure. Justice McKeon is, moves through his cases very quickly. Of course, I've asked that question. I want these cases decided. I'm not trying to delay anything. I'm simply trying to...
client would want to know.
Absolutely. I believe I'm the controlling shareholder of this company, and I want to have that declaration made as quickly as possible. So that's in everybody's best interest.
Yeah.
He's told me, now that we've moved past the whether or not to stay the case, and we're now into the merits, he has not given me a specific timeline. I did show him the assertion that that there's an 8-year backlog. Naturally, I'd be concerned if that were the case. When I read that, that was grave concern to me. Such is not the case whatsoever. Again, what he told me is the Court of Appeals does have a backlog of some years, but not the regular court cases. And Justice McKeon is, he said, has a reputation for being expeditious in getting these cases turned over and decided. That is my view of it as well, especially in light of his very detailed opinion. Clearly, he is taking a significant interest in this case. And so, yes, Mr. Hulsel's correct that I have changed my view, and hopefully that's okay because circumstances change. This Malta court has said we have jurisdiction over this and we're going to decide that, so I respect that. As to the issues of Crowd Shout Limited, I would assert that it is Kansas that is the appropriate forum there because it's Kansas that Mr. Perks and ICAP chose initially to have a declaration as to the directors of Crowd Shout Limited. They could have brought that claim here in the Isle of Man initially. They didn't. They sought to get that declaration from the Kansas court. So I submit that they should be held to account for their actions. In Kansas, the parties have spent hundreds of thousands of dollars. We've had 3 depositions. We're in the middle of a bunch of discovery right now. That case is moving on, is moving forward. And so I believe the proper course of action is to have Malta determine ownership of Crowd Shout Holdings and this action be stayed. I will certainly represent to the court that I'm not going to make any changes whatsoever to the Isle of Man Company Registry for any companies until I have been given an order to do so. So there should be no concern that, as Mr. Hulsel suggests, if this court were to stand down, I'm going to somehow do something nefarious through the Isle of Man Company Registry. I give my word to this court that that will not happen. I believed registering the forms in Malta and in the Isle of Man was just and proper under the circumstances. Mr. Hulsel again says that I'm manipulating the rules of the court and doing all these bad things. What he fails to mention is I have yet to be served in this case. And I want to go into that just a bit. Going to Your Honor's order from 2nd of June of last year for service outside of the jurisdiction, I note that the court specifically says that the service has to be valid within that jurisdiction. I have not been served with valid service. It is invalid. So Regina Murphy was undisputably served with the HC1 claim form in July of last year. A copy was left with her for me. But I had not been living with Regina. She was living in Missouri at the time. I was a Kansas resident at the time. I know the local rules for service. I have talked to my attorneys about it. I have not been served under the service upon me has been invalid.
Right. Well, I think this is the first we've heard of this, isn't it?
No, it's actually in my pleadings. I believe it's in, and I can point Your Honor to it after lunch. I'll find it. But I have made the claim, taken the position in my pleadings that I have yet to be served in this case.
It's a bit of a difficult submission to make, bearing in mind you're here now and you're making submissions to me now.
I'm here because Your Honor has required my presence, and I want to respect this court.
Yeah.
I assert that I'm really here on behalf of GCM Holdings as its director. Mr. Hussle is right. I did file an acknowledgement of service. However, that didn't have an Isle of Man address, and I'm not sure it was a valid acknowledgement of service, therefore. And so I understand this is a bit of a messy situation, but I was led to believe by people in the United States that, okay, I've been served, when in reality I have not been served under Kansas or Missouri rules of procedure. I know that for a fact. And so I think that certainly gums up a procedural issue for Mr. Hussle should he receive a declaration against me that I'm not a director. I'm not sure that order will be enforceable. I don't believe it will be in Missouri or Kansas because I had not been served. And that was the basis for me requesting what I referred to as a protective order by this court. I didn't want to walk in here today and be subject myself to additional service of process.
You say that GCM has been validly served.
Absolutely. GCM was validly served in Malta at its address.
And Mrs. Murphy has been validly served as far as you know.
That is correct. As to the stay, again, it was Crowdshot Limited that sought the very same declaratory relief it now seeks from the Manx Court as to the directors of Crowdshot Limited. It should be held to account for its actions and allow the Kansas court to make that determination. I note that now that I've had an opportunity to read the order, and I appreciate Mr. Hussle providing me with the English translated version.
Well, you haven't had long to read it.
I do note, on page 60, second paragraph, Justice McKeon says, it appears that the merits of this case is almost identical to the merits of the case, and he's referring to the Isle of Man case, because we're dealing with the validity of the stock transfer agreement.
Yeah.
So again, I just think it's improper and that this court continue to hear the merits of this case whenever ultimately, clearly it's going to be decided in Malta. And as for Crowdshot Limited, they sought for the declaratory relief in Kansas initially.
Right. You mentioned earlier you might be able to get an affidavit from your Maltese lawyer about delays in the Maltese system.
I could do that, Your Honor.
Right. Thank you very much indeed, Mr. Burke.
Yes, thank you, Your Honor.
Your Honour, if I could just assist, you requested that we find a couple of pieces of... we filed a chronology with the skeleton argument. Unfortunately, it's not gone in the bundle, but it is in the bundle with the...
chronology here, because it's...
which is somehow...
that skeleton argument, Mr. Murphy, hopefully you
The skeleton argument in opposition of the stay?
that's the one.
Yes, Your Honor, I do. Mr. Hussle provided that to me.
But that's assisted me with finding, in my own witness statements, I can take the court and Mr. Murphy to the pages quite quickly. My witness statement starts at page 659, and Your Honour, if there are any issues with regard to service or correspondence on the acknowledgement of service, it's dealt with in quite a bit of detail. But to assist, as regards the service point, in paragraph 18 at page 665 of the bundle, so this is bundle 2.
No, I'm not looking at the skeleton now.
No, sorry, I'm just going to find for you the emails that you asked for, and they're exhibited to my witness statement, which is in bundle 2 at divider 4. And at page 663, at the bottom, paragraph 11, Mr. Murphy's indicating his wife was personally served. And he says, even though I've not been served nor a GCM, I'm filing the acknowledgement service for myself and GCM Holdings as well. If we go over the page over to page 665, paragraph 18, there's reference there. On the 12th of August 2015, Mr. Murphy was served with a claim for a second time in Kansas by personal service as indicated in the affidavit of service, and there's an exhibit to that in there. So that's just briefly dealing with this service point, which I don't think is in any way a good point anyway. But if I could just take...
It's in accordance with
yes.
law of Kansas, one assumes.
Yes. And if we look at paragraph 21 on page 666, by an email received on the 20th of August, Mrs. Murphy also asked for a 6-week extension to file an answer. Oh, sorry, above that. Oh, yeah, sorry, but prior to that, 665, paragraph 19, emails of the 17th and 19th of August, which are exhibited. Mr. Murphy asked for a 6-week extension to file an answer to the claimant's claim. This further shows that the Murphy defendants have unequivocally submitted to the jurisdiction. And those documents are exhibited. And for example, at 724, request for an extension of time. I think that's one of the things Your Honour asked about.
Yes, that's right.
724, Mr. Holsholl, just for the record, it's Holzol, Mr. Murphy. I'm following up my email from Monday, which I'm requesting an extension of time for filing of the answer. And then the other document I think Your Honour asked about is at 751. And you'll see at the bottom there's an email. Hello, Mrs. Cook. Please see the attached answer and counterclaims as filed by various defendants along with the application for depositions as filed by Regina Galen Murphy. We will pay the requisite court fees next week. And then there's a reply from Mrs. Cook. Dear Mr. Murphy, thank you for your email attachments. Unfortunately, both attached documents are password protected and therefore unable to open the attached documents. Now, we never received an answer or counterclaim as far as I'm aware, and the court didn't either get any reply. So it appears that Mr. Murphy, on the face of that email, tried to file what we say is clearly going to be a defence if he's referring to it as an answer. Then, as far as I'm aware, he's never then since provided the court or my firm with that password or with the document itself. Yeah. So it's somewhat unusual, and there is quite a history with regard to the filings, and it's dealt with, as I said, sir, in some detail in my witness statement. Yeah. I think that was the items that you. Yes, thank you.
It strikes me that in order for me to deal with, to answer this issue about the stay and what is the correct forum, I really do need some further information about delays in the Maltese court system. This seems crucial to me. And I'm wondering if it might be helpful to give the parties a short period of time to file evidence on this point.
Certainly, sir.
Correct me if I'm wrong,
Council
Yeah.
seems to me to be central to this, because if I'm told, or there's some clear suggestion that it's going to take years and years for
Yes.
this case to come to trial in Malta, then clearly I think this court should seize the opportunity to deal with it more quickly. But if it can be dealt with within the next year or 18 months in Malta, then that seems to be logically the correct way to proceed as far as Crouch Out Holdings Limited is concerned, and then it logically follows that this court could then could deal with the issue of Crouch Out Limited.
I can, yeah, I'd be happy to seek some evidence and
perhaps
obviously.
something you could give some thought over the lunch break.
I'm sure Mr. Murphy, he has a Maltese.
Well, he seems to be well able to do that, and I'm sure you can as well.
Well, Crouch Out Holdings have a Maltese advocate. Well, I'm sure we can get something.
Give me some idea what the situation actually is, because at the moment it's what you say about the 8 years is all well and good, but when I actually see the apparent speed with which the Maltese court works by way of these judgments, or this judgment, then it seems to some extent contradict what you say, but it may be a perfectly good
Yeah,
explanation for that.
as I said, my instructions are that it's interlocutory matters such as that are pretty quick, and then it's contested hearing. So.
Okay. So let's just see where we are now. I've heard argument on the stay, and as I say, my initial feeling is I can't give a final ruling on this until I have some evidence about the Maltese court system. The other application is the discharge of the injunction. Now, from what Mr. Murphy was just saying there, he seems to be, I may be wrong, saying, well, okay, I am prepared to go along with this injunction pending the resolution of the issues about the companies, because at the end of the day, it's a matter which is going to have to be determined by the court, and until that's dealt with, I won't be making any further filings, and really the whole situation should just stay as it is, so far as the registry is concerned here.
That is correct, Your Honor. I would acquiesce that I would agree to not do any further filings, nor do I intend to, until there's a final determination as to the directors of Crouch Out Limited. Yes.
Well, the injunction, which you say was wrongly imposed in the first place, and you may well, of course, be right at the end of the day, I don't know. The injunction should really stay in place until the determination of the issues.
I think that it needs some serious amending.
Okay.
Right.
Well,
I have no issue and agree to the issue, the fact that I should not make any changes to the company registry, and I will not. However, the order, the penal notice, is far more broad than that. It deals with my inability to operate the assets of Crouch Out. It's undisputed that the directors, nobody knows how to operate the website other than me. And as a result of the penal notice that was issued on May 19th, the website has been down pretty much ever since. And so Crouch Out's only asset is gone. There's no doubt Crouch Out has incurred millions of dollars of damages as a result of that penal notice. I chose to honor the court's order, and I took my hands off the keyboard, if you will, and so the website's gone. That Crouch Out bought for $3 million. It can't come back. So, though I would like to try to resurrect it, but it has literally been offline for about 6 months, going on 6 months now. And again, I assert that the evidence submitted in front of Deemster Goldring, there were a number of false statements, and I can take the court through that after lunch whenever I formally argue that. So, but yes, as far as my inability to make changes to the company registry, I would certainly agree to that, and I'm not going to make any changes until there's a final determination. Thank you, Your Honor.
Okay. Well, we'll look at that after lunch then. It may be, I don't know, the possibility of any form of agreement as to the word of the order. I'm always keen to promote agreement if I possibly can, but I just put that out there in case there is some prospect of an agreement as to the wording. But
Your Honour, I wonder whether, if Mr. Murphy wants to suggest a suggested amendment, we're happy to consider it. I don't know whether he wants to get some advice on that, whether he, I'm conscious he's a litigating person, albeit clearly a very able one.
Well, it needs to be heard this afternoon anyway,
Yeah.
so I've got time set aside to deal with it. It needs to be dealt with. If you can, if it's possible for you to have any meaningful negotiations over the lunch break, or you need a little bit of time
Yeah.
before we start, then I'm more than happy to facilitate that. But I don't want to waste anyone's time with hopeless negotiations.
Certainly. I think the bigger issue here, Judge, is I just called you Judge. I apologize, Deemster. Is the issue of costs. The court opened up the door to, in its penal notice, saying if GCM has been damaged, or Gabriel Murphy, by virtue of this penal notice, then the other side agrees to cover those costs.
There is an undertaking in damages, isn't there, in the order? There must be, Mr. Halsall. Yeah. But anyway, yeah.
A big part of my argument is going to be, I believe GCM is entitled to substantial damages to be recovered through the claimants by virtue of that penal notice. And so I'm not sure there's going to be a lot to negotiate there. I'm just being candid.
Right. Well, I'll use you. Now, I need to just look at the injunction. Where will that be in the file? Mr. Halsall?
Sorry, I've put away my
So I take,
numbered index.
take all these files with me to my room.
It is.
Yes. The injunction, sir, is in file 4, divider 15, I think. I'll just double check before you...
That is correct.
File 2. But, I see, the application is in file 4. Right.
The application for the injunction is in file 3. I think file 3...
File 2, I think.
Oh, sorry. No, the application for the injunction was the 17th of May. So that's divider 7,
Yes.
which is file 3.
Okay.
Yes.
And then the injunction order is at divider 11, which is in the same bundle.
Good. Well, we'll adjourn now until 2 o'clock.
Thank you.
Thank you.
Thank you, Your Honour.
Now, I'm going to deal with the application to discharge the injunction, which was originally granted by Mr. Goldrain and continued by me. So, Mr. Murphy, here's your application.
Yes, if the court will just give me 30 seconds to get organized. Thank you very much. I had lunch at the courthouse, obviously not this one, but the one down the road.
Oh, very good.
And they had a delay. It was very packed. And so if the courtroom starts smelling like lasagna, it's my fault. It's sitting over here. I didn't get a chance to. So,
Okay, right.
all right.
Sorry to hear that.
If it pleases the court, I'm going to probably be working in file 5 of 5, tab number 17. And this is my skeleton argument to discharge the interim injunction.
I see, yep.
I had initially filed a application to discharge on 30th of May, which was a little over a week after the injunction was granted here in the Isle of Man. And then I followed that up with a modified application, which was filed on the 6th of June, which is the one I'm going to be working through. And this, these documents, you'll see what is highlighted, and that's why it shows up dark if you look at page 1611.
Yeah.
Just so Your Honor understands what's going on. It's so that changes are highlighted between the original application and the application I later amended, if you will. Okay. Before I get into this, I want to touch on the anti-suit injunction so that the court's very clear as to what I was looking for in Kansas. Mr. Hossel is correct, and I'm sorry if I'm still mispronouncing your name. I'm just, I was seeking, GCM Holdings did seek an anti-suit injunction against the claim, CrowdShout Limited, who's the plaintiff in the Kansas action. That anti-suit injunction was not aimed at all other jurisdiction outside of the United States, as Mr. Hossel had represented. Instead, I was merely asking the Kansas court to issue an anti-suit injunction against CrowdShout Limited, since it has jurisdiction over it as a party, to discontinue the case pending before this court. I've never asked for relief from the Kansas court to discontinue the Malta case, just to be very clear about that. So moving on to my request to discharge the injunction, Mr. Hossel and I did take a little time to discuss the possibility of amending the penal notice, and I don't think we're probably going to come to an agreement on terms, unfortunately. So with that being said, I will proceed.
Okay.
First of all, the interim injunction, and I'll refer to it as interim injunction, penal notice, same thing, conflicts with an order out of the Kansas court.
Can we just make sure I've got a copy of the current injunction?
Certainly, Your Honor.
I did look at it earlier on.
And it is tab 15. I think you know that. You're probably turning to it in number 4.
Yes, I mean, it's headed penal notice. As I'm sure you know, this is just a standard notice that's attached to any injunction, really, that just warns you if there is any disobedience to the order, it'll be in contempt of court, and that's really as far as that goes. There's also a very important undertaking in damages.
Yes.
But the whole document is the injunction.
Yes. Understood, Your Honor.
Really, the injunction prohibits essentially any alterations to the existing entries in the public register. That's what the whole injunction is about. It's about essentially maintaining what was perceived to be the status quo prior to this dispute commencing. That's what it does. It doesn't prohibit anything else. It simply, it does prevent there being any changes to the directors or officers of the claimants or the first defendant, which is Nova Scotia Limited. And yeah, it's doesn't make any reference to the website.
You're right, Your Honor. It does not make reference to the website. Paragraph 5 says that I cannot hold myself in any jurisdiction to be the director or other officers or agents of the claimants, nor can I commence or continue litigation. And up until the point of the issuance of this penal notice, as Mr. Hossel is well aware, I have been directing litigation in the name of CrowdShout Holdings Limited in Kansas. CrowdShout Holdings is a party in the Kansas case, and Kansas counsel is taking instruction, or was taking instruction from me as to claims CrowdShout Holdings has asserted against a number of parties, including Mr. Perks individually, as well as ICAP Malta Limited.
So let me just make note of that. You've got, you were instructing lawyers to act on behalf of CrowdShout Holdings Limited.
That is correct.
In Kansas. Right.
That is correct.
Up until this injunction.
Since the injunction was ordered, and I shared that, of course, with my Kansas counsel, the decision was made to assert claims on behalf of GCM Holdings. And so that was my way of maneuvering around the order, but at the same time trying to protect my interests. However, there are legal claims that undoubtedly belong to CrowdShout Holdings Limited, and it's the only party that has standing to bring said claims. And right now, those claims I've represented to the Kansas court, we are essentially halting those claims in light of the Isle of Man penal notice. It is my interpretation, and as I told Mr. Hossel, and as I've told all of my adversaries, everyone's aware that the interpretation of this order is that I am unable to operate the website. The website is undisputably owned by the claimant. By doing so, my interpretation is that's a violation.
Sorry, the first claimant, isn't it?
The first claimant, yes, Your Honor. Absolutely. You're absolutely correct. Yep, it's the sole owner of the website, and if I were to take action on behalf of its assets, operate its assets, that would be a clear violation of the court's order. And consequently, the website, the revenue stream of which is what everyone's fighting over, went offline days after the Isle of Man penal notice was issued. And that, of course, is articulated in number 1611, page 1611, which is tab 17 on file 505. So what happened was CrowdShout in Kansas sought injunctive relief against me on 3 separate occasions prior to petitioning this court for the same relief, i.e. keep Dave Murphy from operating the asset of CrowdShout. The Kansas court denied all 3 of those injunctions. And so ultimately this court granted that, as you know, at the ex parte hearing. I assert that the evidence that was presented to the court in support of that injunction includes some patently false statements made in Mr. Cannell's witness statement. And as I alluded to, and I'm going to take the court through some very specific details of that, in addition, they submitted a witness statement from Regina Murphy, where she purports to not be a director of CrowdShout or CrowdShout Holdings. And there's a lot of significance behind that piece of evidence that was presented. And I'm going to go into that. Obviously, those documents were wholly repudiated by Gina Murphy's affidavit, which evidently she emailed to the court overnight. And I tell you, why don't we just jump right into Gina's affidavit, and it's the same thing that she sent to the court. It's I believe it's Exhibit A to my application of discharge. It starts on page number 1628. This version, as you'll note, doesn't have the court filing stamp on it that the version that Ms. Murphy provided this court earlier today. Otherwise, these are identical documents. Obviously, the statement in paragraph 2 completely contradicts the statements made by Regina Murphy in the Exhibit A to Mr. Robert Cannell's second witness statement submitted to this court in support of the application for interim injunction. And what's really going on is that the party seized an opportunity. I humor that they say I'm tricking people and doing these nefarious things. They seized an opportunity realizing that, as they know, Gina was estranged from me. And at some point in our divorce proceedings, things became adversarial between Regina and myself. And so parties in Kansas, as articulated within her affidavit, bribed Regina Murphy to provide to sign these false documents that were drafted by attorneys in Kansas. I can represent to the court that there is an investigation underway by the FBI on this. And I don't know what local law says about these things, but bribing a witness in the United States is a very, very serious offense. As soon as I learned of these documents, which I had never seen, so these documents were signed by Gina on February 3rd of this year. I did not learn of the existence of these documents until they were submitted to this court. Thereafter, Gina was approached and admitted, here's what happened, I was bribed. We have an affidavit, which is, and she submitted, of course, a witness statement in this jurisdiction to this effect. Page 1661 shows a third party overhearing the bribe. And so once I learned of this, I informed the parties that these documents are rubbish, have absolutely no weight whatsoever. But these false witness statements from Regina Murphy were at the core of the foundation for the application for an interim injunction, saying Kate Murphy must be making fraudulent filings with the Isle of Man Company Registry. Because here Gina Murphy says she's not a director.
So, right, the declaration says she is a director. Mr. Dunker's declaration says that he overheard a telephone conversation when a Mr. Hepting was to pay Mrs. Murphy $2,500 so that she could pay her divorce attorney.
So that you understand, Your Honor, where Mr. Hepting falls into this whole mess.
Yes.
Mr. Hepting is the owner of the Robert Hepting Revocable Trust, a Missouri trust. It is an undisputed creditor of CrowdShout. Going back to those promissory notes I discussed earlier today, he, at the same time Mr. Katz entered into a promissory note, he also lent money to CrowdShout for purchase money to acquire the website. So Mr. Hepting has a significant interest in this case as well. Indeed, the affidavit shows where he references the Isle of Man court opinion from May 19th on page 1656. I think Gabe lost a big decision in the Isle of Man today. You are not a target. But Ms. Murphy actually was a target. Because if we look at the draft order that Mr. Hossel drafted, the relief was sought also against Rogina Murphy. Ultimately, the court, for reasons I don't understand because I was not here, didn't include her as a party to the penal notice, presumably because it thought that she was not acting as a director and took that position. So the other side has known that this was false. These are false documents. They never informed the court.
Yeah, sorry. Let me just be clear then. When the injunction was sought, Mr. Cannell's affidavit, or Mr. Cannell's statement, whatever it was before the court. Now, can we just look at that?
Absolutely, because we'll go to that. Yes.
If you're coming to that anyway later on, that's fine. I just need to know exactly what was said.
Paragraph, so give me one moment, Your Honor.
Sure.
Okay, so if we go to file number 3 of 5,
Yes.
page 849.
Yes.
And this goes right to, so we're going to kill two birds with one stone here, Your Honor. Because here is a patently false statement, paragraph 4, that Mr. Cannell makes to this court. And make no mistake, Mr. Cannell knows this is a false statement when he submits his witness statement before this court. He says, she, referencing Rogina Murphy, has filed evidence with the first claimant's Kansas lawyers, denying that she took any of the steps attributed to her by Mr. Murphy or GCM in relation to the first claimant or the second claimant. If put to the test, Mr. Cannell cannot back that up. There is no evidence to that.
He exhibits something. What does he exhibit here? Does he exhibit it?
He does, and these are the false documents. So if we go to 862.
He might not have known they were false at the time.
At the time, that is fair. But what he did know is that they were never filed. He says specifically to the court, she has filed evidence. If you look at document 862 and 863, and it basically starts on 860. 860 to 863, Your Honor.
The 5th of February 2016.
February 5th
Files
edition.
an affidavit saying basically she has not voted, approved, or otherwise acted to appoint you as a director or anything to do with any changes. She's not approved any changes. Then I see. Then later on, in June, she recants. She says that's not true, basically.
That's right.
Okay, that was on the 2nd of June.
The key takeaway here is that Mr. Cannell is representing to the court that these are filed documents in the Kansas case, when in fact that's absolutely false. And the reason they were never filed in Kansas is because they are wholly inadmissible. Undisputed. And so there are some attorneys in Kansas that are in very hot water over this whole shenanigan.
Well, on the face of it, this is an affidavit from Mrs. Murphy saying she's got nothing to do with Crouch Out and nothing to do with appointing you as a director.
Right.
So that was the 5th of February. Mr. Cannell files his statement on the 17th of May. I don't know when he becomes aware of the declaration of Mrs. Murphy of the 2nd of June, but I suppose as soon as he did become aware of it, he ought to have brought it to this court's attention, I assume.
I would think so, and clearly he would have become aware of it through Mr. Hossel. Surely Mr. Hossel would have circulated my application to discharge, which included her witness statement here in this jurisdiction to his clients. He's taking instruction from Mr. Cannell. I don't think he'll dispute that. Furthermore, in her recanted affidavit, so the key here is, to 850, Mr. Cannell's representing that these are filed documents when such is not the case, and he knew that. He knew they hadn't been filed in Kansas.
She filed evidence with the first claimant's Kansas lawyers. I mean, they're headed in Kansas court.
Mm-hmm.
So,
But they're never filed. They're never presented to the court because...
Does it make any difference?
I think it makes a big difference. Because if they're filed, they're official. They're before the court. And the court can make a determination as to the validity and the circumstances surrounding that affidavit. You have to understand, in March of... So she signs these false documents in early February under the promise of payment. A month later, I'm in front of Justice McKeon in Malta, stating under oath that it is Gina and myself who are the directors of this company. So clearly I had no idea that this situation had occurred in February. It was only through the interim injunction and the papers that were filed where I learned of this. And the fact that she was bribed for this and coerced into executing that affidavit makes the submission of these affidavits from February completely inadmissible. If we go to Regina's recanted affidavit, paragraph number 32, page 1652. And by the way, the person that drafted these false documents for her to sign under the promise of helping her get a divorce lawyer in proceedings adverse to me is a man by the name of Adam Gasper. He's one of those lawyers that are in hot water that I referred to. Mr. Gasper purports to be the lawyer for claimant 1 in the Kansas action. Mr. Gasper was admonished by the Kansas court for notifying GoDaddy to put a lock on the domain name, which occurred back on December 1st of 2015. A hearing was held by GCM Holdings on this issue. So initially they tried to lock up the website by putting a lock on the domain name, undisputed, and this is all in my application. Judge Gurney ordered that lock be removed. It was harming the website. Mr. Gasper was obviously not happy with that decision, and in fact, on the very same day he had to sign the order from the Kansas court to release the lock on the domain is the very same day he drafted and met with Gina and had her execute these false documents. Paragraph number, and of course Gina talks about the meeting with Mr. Gasper and Mr. Spies, who also works at the same firm and purports to be the attorney for Claimant 1 in Kansas. Paragraph 32. At the meeting, and this is on February 5th, I executed a statement and affidavit under duress. These documents were prepared by Mr. Gasper and contained a number of false statements. And there she goes on to repudiate it. Going on to page 1654, paragraph 39, according to Gina, on a telephone call with Mr. Hepting, and Mr. Hepting has substantial communication with integrated capabilities. I have personal knowledge of these facts. Substantial communication with ICAP. He is one of the main reasons ICAP reversed themselves on their resignation. He suggests that he has the ability to approve or disapprove a change of the corporate service provider. But there is no such document to back that up. But this is Mr. Hepting's role in this whole mess. And on a telephone call with Mr. Hepting, she says, a conference call was held with everyone. James Neal, Corey Lagerstrom, who's the ultimate beneficial owner of Defendant 3, Michael Conley, who's the ultimate beneficial owner of Digital. I'm sorry, I said Defendant 3. Defendant 4, Hearn, is Corey. Michael Conley is the ultimate beneficial owner of Defendant 3. And employees, here's the key, and employees of integrated capabilities. So I think it's fair to infer that Mr. Cannell knew that there was this bribe going on. These parties have been conspiring and working together against my interests. So I sure wish Mr. Cannell were here because I would like to cross-examine him on these very issues. But I infer from paragraph 39 that the employees of integrated capabilities that Mr. Hepting was referring to was Robert Cannell. At this time, I believe Mr. Perks was out of the picture, and Mr. Cannell was the one instructing Mr. Hossel. Indeed, we know for certainty that Mr. Cannell is the one who is instructing the litigation in Kansas. We know that because we've been provided a copy of the very engagement letter between Mr. Gasper's law firm, which is McDowell, Rice, Smith & Buchanan, and Crowdshout Limited. It's signed by Mr. Cannell. Also copied on that engagement letter, Corey Lagerstrom.
Just trying to get the timeline.
Sure, I'll give you a moment, Your
So
Honor.
this is the 2nd of June, this statement of Mrs. Murphy.
Yeah, her affidavit is dated
I think it says 2nd June. Executed on 2nd June. Yeah. 1657.
2nd of June. Yes, Your Honor, yes.
When did the matter come before me? It came before me a few days later, didn't it?
2nd of June, Your Honour.
It was the 2nd of June, was it? Okay. Right. On the very same day.
Yes, the very same day I ended up getting this affidavit filed. I used it as an exhibit, obviously, to have the injunction discharged. And this was the basis for my second revision, if you will, because on May 30th I didn't have her affidavit. But by June 2nd I did, and I attached it to my pleading.
I'm not sure. Was this before me in any way, shape or form on the 2nd of June and Mr. Hull told you that?
My recollection is we came back, did the first hearing with Mr. Goldrain, and then there was notice given that we were going back before Your Honour on the 2nd of June, which so that hearing was on notice, but I don't believe that was before you.
You don't think it was?
I don't think so. Well, it'd be Mr. Murphy who would have to put it to you. It was an on notice hearing.
Yeah.
I don't believe that was.
Obviously, my point is that Mr. Hostel had a copy of this this affidavit, I served it upon him on the 2nd of June. And I'm guessing that, I know because I've listened to the recording that it was not a subject brought up on the 2nd of June. I've bought the recordings to all of the court hearings and listened to them repeatedly.
Yeah.
So, substantial key evidence is omitted. It goes back to the theme of the original interim injunction. I brought this up earlier this morning. Your Honor did point out to me accurately that, in fact, the claimants did reference the existence of the resignation letter in their initial HB1 claim form. However, I would think that given the gravity of that resignation letter, that Exhibit D to my original stay application, not just Exhibit D, but B, C, and D. Exhibits B, C, and D to my original stay application include multiple resignations. None of that was provided to the court. There was just a small reference of there's this purported resignation. They don't say it's in writing. They don't say it's on company letterhead. They don't say it's provided to the ultimate beneficial owners. They don't say it was sent to both CrowdShop and CrowdShop Holdings. It's just a very small, vague reference to a purported resignation, when in fact, it seems on the surface, as the court has alluded to, pretty clear it seems that they resigned. But that evidence was kept out of the proceedings when it related to the interim injunction. And instead, a character assassination goes on against Gabriel Murphy, who looks like he's out doing nefarious things. And I submit that these two pieces of evidence are critical in the granting of that injunction, which I don't think the court might have granted if it had the whole story. And make no mistake, leaving this out of the court's privy was not a simple oversight. The claimants, those acting in the name of the claimants, have a history of spinning stories and telling half-truths to the court in order to fashion a fable that works in their favor. So in reality, that evidence was never admissible, and Mr. Kennel likely knew and participated possibly in the agreement that, we've got to figure out a way to get Gabe Murphy shut down somehow, and that's the words they use. How do we shut down Gabe Murphy? Let's bribe his wife, who's estranged from him, going through divorce proceedings. Let's bribe her to sign these documents because we know she needs the money to hire a divorce lawyer in Kansas. Pretty serious stuff. There's no dispute that because of the granting of the injunction, that the website went offline as a result of my strict adherence to that order, and has remained offline since. The court may recall, this is a website that was generating hundreds of thousands of dollars of revenue. It's done zero for the last roughly 6 months. We're left with two companies that are just assetless corpses at this point. We're really fighting over companies that are worthless.
Presumably the website can be resurrected in due course once we know who owns the domain name, once we know who owns the website.
Well, I think there's no dispute, Your Honor, that the website's owned by CrowdShop. And who owns the company?
CrowdShop, yeah.
Right.
The whole thing has got to be, I suppose, put in abeyance until this dispute can be resolved.
It's in everyone's interest that the website be up generating money, I think, and certainly Kansas Council.
How is that going to be achieved?
How is that to be achieved? Discharging the injunction that's prohibiting me from being able to do anything on behalf of CrowdShop Limited. I certainly, those that purport to be the directors in this jurisdiction have no idea on how to operate the website. Mr. Perks has admitted that in his deposition testimony. So the only way the website can possibly be resurrected is two things. One, I would need to be able to do so without risk of imprisonment, as it stands under the penal notice right now. And two, is an issue of cost. There's going to be considerable cost to resurrect the website. The website was based off of proprietary technology, as I mentioned, that allows people to extract out the audio from an online video file. At the end of the day, it's software. And again, because I was unable to do anything, including pay any of the fees which I had been paying to the hosting company, all of that software is gone. So I would have to, and this is articulated in my tab 17, my request to discharge, I'm going to have to redevelop that software as a first step. And so,
but if there was some way of getting the website up and running, any revenues would have to be held in some form of escrow account pending the resolution of this dispute, wouldn't it?
yeah, I can speak to that, Your Honor. CrowdShout Limited had requested the Kansas court order the parties that an escrow account be established and any funds generated from the website be placed in that escrow. And that is an order in place right now by the Kansas court.
Oh, so there's an order, isn't
There is, yes, Your Honor. Yes. That order is in place, but there's no revenue being generated by the website.
Okay, that's because of this order.
That's correct.
Let's just go back to the order, precisely what it says. Sorry, I keep losing it. It's around.
That's okay. Tab 15, Your Honor. 1586.
Pretty much right at the very end of everything, isn't it? Right. Paragraph 5. The problem, is it, as far as you're concerned?
4 and 5, Your Honor. Must not purport to do anything as or on behalf of the members of the first claimant. Yes, in their own pleadings, they say that because I haven't given up control of the website, this was why they wanted to seek an injunction against me in Kansas all the way back in January. So they admit that by me operating the website, I'm purporting to act on behalf of CrowdShout Limited, which makes sense because CrowdShout Limited undisputably owns the website.
So if you were to get the website up and running, you'd be in breach of this because you would in that way be holding yourself out as a director or agent of CrowdShout Limited, effectively.
Correct. Paying the hosting fees, doing those things, those are all to the benefit of CrowdShout Limited.
Where's this escrow order, if I can call it that, where is that? I've got a copy of that in the papers, Mr. Murphy, you know?
No, Your Honor, I do not, those are not in the submissions, but if it pleases the court, I'm happy to provide you with a copy of that order.
When was that granted?
That order was granted,
It's a Kansas order.
yes, Your Honor.
Yeah.
Certainly earlier this year, I believe it was May or June of this year. It may have been earlier. I would have to look that up. I apologize, I don't have an exact date for you. So if this court were inclined to discharge the injunction, you know, those revenues, if there were any to be able to come of a resurrected website, would ultimately flow into an escrow account, and those revenues would ultimately then be held onto until a determination is made.
Yeah.
But that's in everyone's interest, because if I'm right, there are considerable damages that have occurred. If I'm wrong, certainly CrowdShot Limited wants to generate revenue. So it's in, I believe, everyone's interest that an attempt is made to resurrect this otherwise dead asset. Bigger picture, nobody certainly likes to have an injunction hanging over their head with the threat of potential imprisonment. Again, I believe that the court has been deceived to believe that I'm doing things that are fraudulent and abusive when you look at the resignation letter and all of the documents, it seems like I'm doing things that any reasonable person would do under the circumstances.
You would be prepared to give a written undertaking, would you, to this court? You wouldn't make any filings at the company's registry here in relation to CrowdShot Limited?
Yes, Your Honor. I absolutely would.
That would be a solemn undertaking that you
Absolutely.
would do that, and if you did it, you would be in contempt of court. I suppose that might be one way of dealing with it.
Yes, and I think that's a great way of dealing with that. I can, again, assure the court that I'm not going to do anything else with either the Isle of Man Company Registry or the Company Registry in Malta until there's a determination on these matters. I did this again because in Kansas, the common theme that is told to the judge there is, look, Your Honor, Gabriel Murphy says he indirectly controls plaintiff, CrowdShot Limited, but here, look at the company registry in the Isle of Man. This is what it says. And so what they've really done is they're hijacking this company over the ministerial act of not updating the company registry. Something that they promised themselves to do but failed to do. It's their own negligence that led me to have to take the action that they themselves promised that they would do back in November of 14.
Well, what the company's registrar here doesn't want all sorts of piles of documents coming into and conflicting with each other, and it's just chaos.
Certainly.
So the whole thing just needs to be frozen here. The public record needs to be frozen until the dispute's worked out.
I totally agree with that, and I would absolutely agree.
It would be interesting to see this Kansas order, which seems to, presumably, if it's an order of the Kansas court, linked with this dispute, if it seems to mandate some form of reactivation of the website, that with the proceeds being held in an escrow account, that sounds very interesting, but I can't give any view on that unless I've got a copy of the order, unless it is buried away in these 800 pages. Any knowledge of that, Mr. Paulson?
I know there was an order for a lockbox or something, but
Yeah, exactly. Yes, sir.
Okay.
Exact nature.
Precisely.
What's a lockbox? Sorry.
Well, that's the phrase I recall. But
He's exactly right. Lockbox escrow. Same thing. Yeah, we're going to lock these funds up in an escrow. Yes, that's Mr. Hustle's absolutely correct. And using the proper terminology.
Yeah.
I was seeing if maybe I know I had attached the case history for the Kansas claim as an exhibit in some of my filings, but I do believe that, and there would be notes, bench notes as we refer to them, referencing this lockbox. However, I believe, to the extent I have, yes, I found it. Page 1665. And it appears as of June of 2016, I don't see where there was the hearing. I see a hearing on May 9th of 16 at the bottom of this page. That's on the appointment of a neutral. Yes, it was, I can represent now to the court that lockbox order, as I'll refer to it, was certainly entered at sometime after June 3rd of this year by the Kansas court. And if it pleases the court, I'll be happy to furnish a copy to the parties, if that's helpful.
Yeah, I think it probably would, yes.
So, of course, I would be honoring the Kansas court order and directing revenues from the website, if it were resurrected, to be deposited in that lockbox account.
Yeah.
So, going back, again, Mr. Cannell knew of that Mrs. Murphy's affidavits from February, what I'll call the false affidavits, were never filed in Kansas, but he represented that to the court. Mr. Cannell clearly knew by June 2nd, and everybody knew, that Gina Murphy had repudiated the things that she had said, but that was never, ever presented to the court. And all the while, exhibits B, C, and D were never laid in front of the court to say, yes, Mr. Murphy has filed these things, but here's also the other side. We did send him these emails and this letter, which would rationalize my actions. Instead, they demonize me as being somebody that's fraudulent and abusive. Going to statements within Mr. Cannell's second witness statement, again, which was in support of the original application for injunction in front of Deemster Goldring, paragraph 14, Mr. Cannell states that,
So which page is that, Mr. Murphy?
that's, I'm on 1621, sorry, Your Honor.
Thank you. Yes, I got it.
And I'm pulling this directly from his witness statement, which is obviously contained in the bundle.
Okay.
He says, quote, there were no resignations by the individuals concerned at the dates alleged or at all. And again, not to belabor the point, but no one says, well, we did send these letters and we did send 3 emails to Mr. Murphy indicating we were going to resign. They don't inform the court that, oh, we did even in fact file a notice with the company registry saying we were going to resign. I believe these are very significant facts that if they were before this court, I don't want to speculate what the court would do, but certainly the court was not informed as to all of the material facts it needed to have in order to make a determination as to whether or not to grant that interim injunction. Mr. Hussle, in his witness statement, says that Mr. Murphy's doing all of these things without the knowledge of Appleby. Well, Mr. Hussle has no idea what my communications are with Mark Embry or Christopher Cope at Appleby at that time. He's merely speculating as well. Mr. Cannell goes on to speculate in his second witness affidavit. If we were to go to file 3 of 5, page 854. which is the actual witness statement of Mr. Cannell. And I'm on paragraph 12.
Yeah.
Paragraph 12, second sentence from the bottom. Granted, he does put a knowledge qualifier in here. To the best of my knowledge, Ormco PLC does not hold a license to provide corporate services, nor act as a registered agent, and does not claim to provide such services. Mr. Cannell suggests to this court that, again, I'm using a registered agent address at Salisbury House, which I have no affiliation with, when in fact I had an agreement, an engagement letter with Ormco PLC to act as my registered agent. That's undisputed. But I find it bizarre that Mr. Cannell, who is a director of a corporate service provider, doesn't even know who is authorized or not authorized as a registered agent in his own jurisdiction. But again, this is used to make it look like I'm just stating I have relationships with people that I don't and making all these fraudulent filings, which is, when you look at the evidence, that's simply not the case. Now, I can go on and point out other false statements made within this affidavit if it pleases the court. I don't want to belabor the point, but I've given two prime examples, and I could give more. So we've got this false statement submitted to the court. We've got the non-disclosure of the engagement letters and the engagement emails, exhibits B, C, and D to the stay application. We've got the non-disclosure of the repudiated affidavit from Gina Murphy and her witness statement repudiating those affidavits filed in this jurisdiction.
Yeah, look at page 860, just so I'm clear about this. What's this statement? This is a statement.
860?
Yeah, 860.
So there were two documents that were executed by Gina at the same time. The affidavit, so both of these documents, Your Honor, so 860 through 863, are obviously two different documents, both of which were drafted by Mr. Gasper, both of which were executed by Gina. I'm not sure why they chose to do two versions of, this statement. I can't speak intelligently to that. Yeah. I actually believe that 860 is doctored in so much as it's blank at the top when I think the original, what she really signed, had the Kansas case heading at the top of it, just like the other document, 862. Yeah. If you look at it, it's about the same distance spread, the blank space is exactly where the caption heading would fit. I can't explain any of this, but that's merely my observation. I don't know that for a fact. I'm very careful to not state things that I don't know are true, but it seems that, yeah, that this had a Kansas heading on it at one point, but it was blanked out when submitted to this court. Does that answer your question, Your Honor?
I think it does, yes. Thank you very much. Yes. Righto.
So as a consequence of the entrance of the penal notice and my strict adherence thereto, the website's gone. It will never be resurrected to where it was before. I know that given my experience in these matters. The website made so much money because of what we call SEO rank, and Your Honor may be familiar with that term. Right. Search engine optimization.
Oh, right, yes.
Okay. So the way people would find this site would get over 100 million visitors a month. And the way that occurred was people would go to Google and search for video MP3 or YouTube MP3 or extract audio from video, some of those keywords. Google doesn't even recognize the site anymore. So it ranked in the top 2 or 3 search results. Now it doesn't exist. The site's offline. It's not in Google. It's not indexed by Google. Building your, what they call rank, your search engine rank, is an extremely time-intensive process. You don't just get that back overnight. The only, and that's a good question, Your Honor. For paid advertising, you certainly can. It's cost prohibitive to pay for that placement. If you were to humor yourself tonight and search for YouTube MP3 on Google, you'll find nobody's paying for that position because this is a free utility. And so it would cost, the economics don't make sense. Only having a natural, organic, as we refer to it, rank in that top 3 spots is how this website would generate substantial sums of money. But before we even get there, we have to redevelop the software that's gone. And so we have a considerable amount of cost in just trying to resurrect this asset. And so I submit that the injunction should have never been granted. It would not have been granted had this court seen all of the evidence. The parties intentionally kept the court in the dark on the resignations, all 3 of them, on the filing with the Isle of Man to resign, on Gina's repudiated affidavit. And Mr. Kennel has submitted a false affidavit, a false witness statement to this court. And it is for those reasons that I respectfully request that Your Honor discharge this application and allow me to submit an application for damages, which this court has opened the door to in the penal notice on page 1586.
Yes, the undertaking is actually on behalf of CrowdShout Limited and CrowdShout Holdings Limited, not anyone else.
The undertaking, the application, you'd say?
Yes, the undertaking to pay any damages resulting from the grant of the, should we say the wrongful grant of the injunction, is an undertaking given by CrowdShout Holdings and CrowdShout Limited. So it's a bit of a circular matter so far as you're concerned. You probably would have preferred to have an undertaking by, presumably,
I think
or something like that.
Well, I submit to this court that it's really not an undertaking by those companies. Again, those companies are, Mr. Hossel is masquerading under the guise of authority of these companies. It's really the interest of defendants 3, 4, and 7, specifically defendant 7, that's directing this claim. That was the one that wanted to get the injunction. CrowdShout.
7 being, sorry, just remind me.
7 being Integrated Capabilities Malta Limited. Those are the parties that were after the injunction. The real CrowdShout Limited would have never wanted this injunction because it's undisputed. I'm the only guy that can operate the website. And so the claimants would have never sought the injunctive relief that was requested of this court.
Right.
And so, if granted, my application would ask this court to direct that it be those parties that be held jointly and severally liable for the damages that have occurred as a result of this penal notice being issued under false pretenses.
You think it should be, just to be clear, it should be Integrated Capabilities Malta Limited, the 7th defendant, and the other one was?
Defendants 3, 4, and 7, Your Honor.
3, 4, and 7.
The ultimate beneficial owners of those entities are named specifically within Regina's repudiated affidavit. As Mr. Hepting has talked to these parties and agreed that, okay, we'll give you $2,500 for your divorce lawyer. You know, it's a quid pro quo is all this is. We're going to give you $2,500, Gina, and we want you to sign these documents. In fact, she was told, sign these documents and we'll leave you out of the Isle of Man case. We'll leave you alone.
$2,500 isn't going to get you very far with the divorce lawyer, I would imagine.
It was a very low bribe, let's just say that. Yes, Your Honor.
Okay. Right, I think I've got your point. Thank you very much, Mr.
Okay, thank you for your time,
Thank
Your
you
Honor.
very much, Mr. Holden.
Your Honour. Now, been some interesting submissions from Mr. Murphy today. The first thing that we would say is that Mr. Cannon would completely refute any allegations at all that he's misled the court or misled anybody. And there is absolutely no proof that he has on the basis of what I've heard today. The application was made actually on notice to Mr. Murphy's then lawyers, Appleby, but because of the circumstances, which were with respect to Mr. Murphy's own fault, they decided to seek a release from acting for him, and that's why the same date as the injunction was made by Deemster Goldrain, there's the order releasing Appleby from acting for him. Now,
but was it on that? I thought it was initially granted ex parte, no?
It was granted on the 19th of May, so it's in Divider 10 and Divider 11. The first injunction is granted in Divider 11. Now, what actually happened, we served it on Appleby, so we prepared the application. It was lodged in court on the date of the application notice, so it was lodged on the 17th of May. On the same day, it was served on Appleby, who were the advocates on record for GCM and Mr. Murphy. So this wasn't actually an ex parte application. So it was done as an on-notice application. Notice was given to the advocates who, on the date it was made, were actually acting for both GCM and Mr. Murphy. Unbeknownst to us, around about that time, they were applying to be released from acting for it. So I can't comment on what his lawyers did at the time, but they were his lawyers at the time. We served notice on his court-recognised lawyers, the lawyers that were on record. They, for their own reasons, sought to be released from acting for him, and that's why that order, Divider 10, the court order of the 19th of May of Deemster Goldrain, that's the order releasing Appleby from the record. So that was made at the same time His Honour made the injunction. I think His Honour decided to cautiously view the matter in the tests he applied as an ex parte application.
Well, effectively it was an ex parte application because there was certainly no one there to represent Mr. Murphy. He wasn't there, for whatever reason.
Yes.
But effectively it was an ex parte. Short-term injunction,
it was a short-term injunction. It was dealt with very sensibly, I think, by Deemster Goldrain, and he provided for a date for it to come back on the 2nd of June.
Came before me.
Which a date Mr. Murphy was obviously aware of, but he didn't turn up. Now, he's referring to people misleading the court because there was some purported statement of Regina Murphy of the 2nd of June. Well, the 2nd of June we were in court here, and he could have been here or had a representative here.
But I suppose the point is, even if that matter was not before the court on the 2nd of June, that statement could not have been brought before the court on the 2nd of June. It should have been brought to the attention of the court very shortly thereafter, because you would have an obligation, would you not, to inform the court if it became clear that something represented the court was not correct.
Well, my clients are not at all happy that this is correct, and so the difficulty they have is there's very conflicting evidence as to what Mrs. Murphy's position was with this, and certainly Adam Gasper has confirmed to me that he completely refutes the allegations made against him. In fact,
he's the man who's supposed to have brought it.
He's the attorney who acts for CrowdStrike Limited in the American litigation, who I seem to recall Mr. Murphy made various allegations against, and he referred to I think page 1636 of a subsequent statement from Mrs. Murphy, where there's quoted
a text from Madam Gasper. Gina, I'd appreciate you letting me know if Gabe's lawyers are threatening you or asking you to commit to false testimony, which to me doesn't sound like a dodgy lawyer trying to put pressure on anybody. But that's where we are. We've got two completely conflicting statements from her. But the fact is, this actual application for an injunction was clearly a slam dunk application. I mean, you just need to look at the actual forms, the IM4, the IM12, lodged in the registry by Mr. Murphy, which were clearly unlawful forms. He didn't have authority to make them. They were misleading.
In relation to Appleby, there might be some argument on that. But what about the fact that he regarded himself as entitled to file the forms, bearing in mind all the history of the matter?
Well, there's one, the IM12, which is at divider 901, sorry, page 901, says the registered agent is Appleby International. Attention, Mark Emery, and then the address. Signed on behalf of the company by Mr. Murphy. Now, as was said in the application, there is no Appleby International. To be a registered agent, you have to be a licensed fiduciary. Appleby are a firm of advocates. They don't have a licensed fiduciary. This was just a complete misleading, unlawful act by Mr. Murphy. Then there's the other one where he's filed the IM4, which is at in file 3, divider 8, pages 899 to 900.
Sorry, divider one?
It's in file 3, divider 8, page 899.
All right, what page is before the round?
Yeah, and that's the statutory form for the change of registered officer. That says, on the 3rd of May 2015, members and directors resolved to change the registered office to 37 Apple Street. Well, he knows he doesn't have authority to put that in, and it says, signed Gabriel Craig Murphy, director. Now, he knew that these forms, he had no authority to put these forms in, and he knew they were completely misleading. And this is exactly the kind of thing that the courts need to protect against with regard to public records. If you've got a place such as the Isle of Man, where important parts of the business is fiduciaries and companies, and there's a company's registry, the company's registry, they can't be expected to check that everything is valid, and in fact they specifically don't. They rely on people to act honestly. And clearly this filing of these forms was not something that Mr. Murphy was entitled to do at all. And that's why
There might be some argument that he had the right to recite the resignations of Mr. Cannell, Mr. Perry, and his appointments as director, because on the face of it, looking at the documents which we looked at earlier on, there is an issue there, isn't there?
There's an argument he has about that, but he knows that that's entirely disputed, and he knows that they deny that they've resigned, that they've retired, and that's all dealt with in the particulars of claim that he had some considerable time before that. And it's, you know, this is something where this is someone trying to completely subvert the court process, the ongoing litigation, and the company's registry by filing forms he knew he simply wasn't entitled to file. And we know as well that
The particulars of claim, yes, they were...
they set out all this and they explain.
That's right, sometime previously,
Yes. So that's we say clearly the order was correctly granted. It retains the status quo. As I indicated, it was served on Appleby. They attended, but they'd already applied, obviously unknown to us, to be released. Now, Mr. Murphy has raised a couple of points about Mr. Cannell's witness statement. He seems to be making great play of paragraph 4, which is at page 849. And he repeatedly was saying that Mr. Cannell was falsely saying that he'd misled the court in saying that he filed that this evidence had been filed in court. And what it says is she's filed evidence with the first claimant's Kansas lawyers, denying that she took any steps, and that's what's exhibited.
Yeah.
And that, to his knowledge, was exactly correct.
So, again, getting the timeline clear here, Mrs. Murphy seems to have filed, there's a statement of the 2nd of May,
Yes.
860. There's a statement affidavit 862.
Yeah.
Right. They are contradicted by a later document, which is
I think Mr.
floating around somewhere.
Murphy referred to it as the 2nd of June.
Yes. That's right. Same date as I continue the injunction. So the argument is, I go back to it really, that notwithstanding all that you said, it was really up to the claimants to bring this to the court's attention, to say, well, look, Mrs. Murphy said one thing to us, but she's now saying another thing, namely that she is actually a director of the company.
But at this point, Mr. Murphy, the application had been made on the 17th of May. I appreciate it's somewhat unusual because it'd been made on notice, but because of circumstances between Mr. Murphy and his lawyers, they were then released.
Yeah.
We came back on the 2nd. Before then, on the Divider 14 application notice of GCM Holdings dated 30th of May.
So they applied to discharge.
He's applying to discharge. And we come back on for an on-notice hearing on the 2nd of June.
It's actually for me to look at the situation today, isn't it, really, and see what the position is today, bearing in mind all the evidence that's been filed.
Yes, but certainly I don't think there'll be any criticism of the claimants with regard to this, because these are papers filed by Mr. Murphy subsequently.
Yeah.
Now, and of course, the 2nd of June,
He applies
they're in
to
America,
discharge-
they're behind us on
He
time.
applies to discharge the injunction very promptly, doesn't he?
He does.
Yeah.
Yeah, he does.
He files all the evidence, right, and it's only now that, of course, the matter comes before me on a proper inter partes basis.
Yes. And there haven't actually been any directions for the claimants to file anything on this. We obtained our injunction, and then Mr. Murphy filed this application, and this has been set down for a hearing. So there's not been any directions for us to file anything further. But certainly, my clients do not accept this situation at all with regard to Mrs. Murphy, and they're very sceptical about it. I know Mr. Murphy before referred to an independent witness referring to hearing a bribe. Well, Your Honour read that statement that was highlighted by Mr. Murphy this morning, and that didn't sound like a bribe. It was just someone saying, I heard him say, this man saying he was going to pay $2.5 grand for legal fees. Now, that,
Well, she said in the statement.
she's saying
she
that.
was bribed. But
Yeah, I said Adam Gasper would say to the contrary. So there's a complete difference on evidence on that. But the fact is, this injunction was obtained because Mr. Murphy had filed the IM4, the IM12 that he wasn't entitled to file by any consideration of the matter. He knew there was an ongoing dispute as to the directorships. He knew who the registered directors were. He decided to subvert the whole litigation process, the company's registry, by filing these forms, clearly without the permission of Appleby, who obtained a release. Now, they were obviously in a very difficult position because this was something done by someone who they were acting for, so it was utterly conflicted. Now, this morning Mr. Murphy was basically saying that he thought the injunction could stand, and his concern was, and he was happy with it applying to the fact that he couldn't file any forms. He seems to have moved his position somewhat this afternoon. we say this injunction is obviously necessary. Mr. Murphy has only this week on Wednesday has exhibited to the on Wednesday has exhibited to my witness statement of yesterday, written to me saying I shouldn't be representing Crouchout Holdings Limited again, which is actually arguably a breach of this injunction, because he's implying that he's the person who's entitled to instruct lawyers for them.
That's his case. That's what the dispute's all about. It'd be a bit harsh to penalise him for that, wouldn't it?
So
I suppose.
we say this was an absolute slam dunk of an injunction. It was obvious grounds for one. That it was dealt with properly. Mr. Murphy clearly has something going on in the background with his ex-wife. What exactly their personal circumstances are, we don't know. Our case is that witness statement was given properly, and certainly Mr. Cannell had no reason to doubt it at all, and still does not. Certainly the position of the claimants is that it's all somewhat suspicious. But we are where we are, and we have an injunction which we think holds the ground that should be there pending the resolution of this litigation, and there's nothing in there that Mr. Murphy could properly object to in the circumstances, in the knowledge of the ongoing dispute.
What about this bid to facilitate the Kansas order about the escrow account and the argument that it's that?
If Mr. Murphy has some proposal that would be sensible for everybody, obviously he could make that. He could if there's some way that this could be operated, which he felt would be in everyone's interest, he could make a proposal to do it, and then the parties could consider it and see whether any amendment needs to be required.
Is this the first you've heard of this proposal?
I believe so. I don't think. If Mr. Murphy wants to write to us and say, I propose an amendment to the order that would facilitate the following, if it then clearly was in everyone's interest and protected everybody, then my clients would obviously have to give it good consideration.
Yeah.
But at the moment, this order simply holds the status quo, and
well, as I think I've really already commented, it's very difficult for me to try and facilitate, which I'm obviously keen to do, the re-energising of this website and Kansas court order in the interest of judicial comity. If nothing else, if I don't even have the order for me, the Kansas order, so it's not difficult for me to facilitate that.
If Mr. Murphy wants to, or his Kansas lawyers wants to write to us with some proposal to try and sort that out, then obviously we can consider it, because clearly it would be in everyone's interest. If there was something that could be done,
It needs to be a huge revenue stream here, which is being neglected. It needs to be.
if that is
the revenue at the end of the day will be a matter for determination.
Clearly it would be in the interest of the claimants if that was something that could be done.
Yeah.
And so if something sensible and sincere was actually proposed, they would have to consider it. And
Not to be the subject of an application to the court, but.
Exactly, so a sensible solution could be suggested, and in open or closed correspondence, whichever Mr. Murphy was advised about, and then that could be considered, and if necessary, if he felt that this was being dealt with sensibly, he could consider an application. But we say this order was entirely properly granted. I dispute completely any allegations that it wasn't dealt with appropriately in the circumstances. And this has happened twice in two jurisdictions. It's happened in Malta, there to get an injunction in Malta, and they've had to get one here. We've also got, I don't want to go over this again and again, but all the evidence of, which I'd ask you to consider in my first witness statement, of all the misleading items about addresses for service and there's just a theme to this as to how Mr. Murphy, able as he is and eloquent he is on his feet, there is just a theme to how he conducts himself, which runs consistently throughout this litigation, which is that he will say whatever he thinks is necessary to get there. Now, I've had emails which have been referred to in court before, indicating that I was lying about serving things at the address for service, which was completely untrue. We had the situation with that address for service in Victoria Street, where we had an actual email from the provider there saying it wasn't the address for service, and then subsequently they decided they were going to be the address for service. So this is obviously a factually complex, interesting case with interesting parties, but the fact is this injunction was properly applied for, properly granted, and is necessary. And the penalty being it should stay pending the resolution of this litigation. And as I said, if Mr. Murphy has any sensible proposal for a variation which he thinks is necessary in the party's interest with regard to the assets of Crouchside Limited, my clients would consider it. Because it would have to be a sincere proposal, a workable proposal, and obviously that could be a proposal through the American attorneys or however Mr. Murphy would like to do it. But clearly, I can only reiterate that the circumstances of those form find, this is something that the court and the registry in the Isle of Man must be very cognizant of, that forms for company registry are extremely important. They have to be filed truthfully and lawfully, and these clearly weren't. Utterly refute.
Well, so far, certainly it seems, I'm with you on the issue of Appleby, that seems a bit odd. But so far as the underlying issue of who should be the directors are concerned, there's a bona fide dispute about that. Your point is that it shouldn't have been filed, bearing in mind that there was litigation about this, and it was really, you would say, somewhat vexatious to make those filings, bearing in mind that we all knew that was going to be dealt by the court in any event.
Yeah, it was, as I said, just a direct attempt to subvert the process of the litigation and go through the back door of the registry to get the result that he wanted. And clearly that was wholly inappropriate, and we'd be concerned that it would happen again. So if there are any specific matters from Mr. Murphy's submissions that I can assist you with, I will endeavour to do so, Your Honour. Again, I'm disadvantaged somewhat of Mr. Murphy is extremely cognizant of his version of what's happened in America, and there'll be a lot of items there that are outside my knowledge, and I don't want it to be said that I'm admitting them by not countering every single thing that he said, because I simply am not in a position to on behalf of the claimants. But suffice it to say, we are entirely clear that this was an appropriate application in the circumstances. It was properly dealt with. Deemster Goldgrain didn't grant everything that was asked for.
No, I noticed that. I think there was an application for an account.
Yeah, he didn't grant that. He didn't grant
that quite properly.
He himself said he felt that there shouldn't be an order against Mrs. Murphy, and one wasn't made. And
What about
so
this point that the various resignation documents were not brought to his attention? I mean, I'm aware of them now, of course, but it is said that he just wasn't given the full picture about the various alleged resignations.
The particulars of claim were filed with the application, and they're referred to in the application skeleton argument. And His Honour actually said he was considering potential arguments for Mr. Murphy, and in his transcript he actually said, no doubt Mr. Murphy will say he's been subject to a fraud or improper action by the other parties, and so the Deemster was cognizant of the fact there would be another side to this. And I can't, I'll have to find the transcript of Deemster Goldgrain is at page 931.
Yes, he says at page 932, right at the very bottom, by Mr. Murphy, that he's been subject to fraudulent financial dealings on behalf of the claimants, as referred to in his email of 9th May 2016, which is provided to the club on.
Yes. So this application was made on notice to his then lawyers, but because of the circumstances, which frankly were clearly an issue between Mr. Murphy and his lawyers, they suddenly were released. It was brought back on notice. Mr. Murphy had notice of that hearing. That was his opportunity to come back and raise anything. He didn't. In fairness, he was dealt with extremely sensibly and as one would expect by the court, and the matter, he was then entitled to proceed with the amended and proceed with his application to discharge. This witness statement of the 2nd of June, presumably that's been, I think, witnessed by a notary public, so that presumably was in business hours in America, and one would assume that there's a good few hours behind in Kansas from the Isle of Man, and we were in court on the 2nd of June. But of course, he then subsequently, in his application, has filed that information. So I don't think there can be any proper criticism of the claimants with regard to this application. And with respect, Your Honour, I would ask that the application to discharge be dismissed. As I said, I would just reiterate that my clients would give consideration to any sensible proposal with regard to the operation of. Obviously, there needs to be American advice because there's American litigation as well. But
Thank you, Mr. Hossel. Very briefly, Mr. Murphy, anything you want to say on the bar?
Certainly, thank you, Your Honor. And let's take a look at Deemster Goldring's transcript in a little further detail. Page 932. And I appreciate Deemster Goldring knowing I'm not there trying to put himself in my shoes if I were. And it's clear from both A and B that he never contemplated, at least from what I'm reading here, you don't see that Gabriel Murphy would maybe argue that they resigned. Nothing about that in there, because Deemster Goldring didn't have that knowledge or information.
Well, he must have had the particulars of the claim, which does set it out.
And we've gone through that, you're right. But it would seem to me that surely an advocate owes a duty of candor to the court and to say, yes, Gabe Murphy did these things, but here are the resignations. Here are the documents, if he were here. These are the things that he has already represented to this court as to why he would take those actions. So my view of paragraph 10 here is Deemster Goldring didn't have that knowledge. At least certainly it was not in his mind when he was trying to perceive the strands of defense in my favor. I also note the email that Regina sent to the court yesterday. I find it interesting that Mr. Hossel, the very day that he applied for the interim injunction on May 19th, sends an email to Mr. Gasper. Sends an email to Christopher Wilson. And I'm on page 2 of this.
Mr. Hossel's...
No, I'm sorry, Your Honor. This is the document that Ms. Quine provided me today. I think Your Honor had it this morning. Yes, sir.
This is Regina Murphy's...
Yes, you'll see on the bottom of page 2 we have Mr. Hossel sending an email on May 17th to Chris Wilson, copying Mr. Gasper. And in this email, he wants clarification as to whether or not Gina had knowledge of the filings of these forms. And he asked that they acknowledge receipt, confirm that the client did not assert that she's a director, and confirm she doesn't oppose. Mr. Hossel never received a response. But yet, he didn't disclose that to the court. Clearly, he had questions as to the validity of this, thought maybe that Gina had signed these. It bears her signature. And so, again, this doesn't make it in front of the court that they did not confirm that she was not a director, and that, yeah, I think that, again, it's just another example. I fancy Mr. Halsell says that I'm doing all of these bad things. It's just simply not the case. You know, as to Appleby, I will represent to the court that their withdrawal was purely a financial issue. The court should understand that this was my sole source of income. And by choking off Westmark from receiving money, their strategy is Gabe Murphy can't fight back. Make no mistake about it. And that is articulated within Mr. Hepting's text messages to Gina when they're trying to recruit her to sign these false documents. Make no mistake, these are false documents. The other side's known it. Clearly they knew it by June 2nd. Whether or not they had it before the court hearing or not, I'm not prepared to respond to because I simply don't know. But what I do know is they had it shortly thereafter. Did they ever bring it to the court's attention?
Well, the point is, I think, that you made an application to discharge. Pretty much.
Very soon, 10 days, I think. Yes.
So really, and then you put this evidence before the court.
Yes.
So the matters before the court has taken a long time to get to the court for various reasons, but it's a matter then which becomes inter-parties, and the matter has been brought to the attention of the court now, certainly.
Yes.
Brought to the attention of the court by you when you made your application to discharge. So.
That is true, Your Honor. Mr. Halsell also continues to say Gabe Murphy knew, whether it's these were fraudulent documents that he was filing, and I wonder how Mr. Halsell can possibly get into my mind. But since I'm here, I will say that I did not know that these were at all false documents. These are very, again, something that any normal person would do under the circumstances. In light of the resignations, so on and so forth. I'm here today pro se, not because I want to be. I would much prefer to have a Manx advocate arguing my case. But given the circumstances that integrated capabilities and other parties have usurped control of the claimants, the net result is they have choked off my only source of income. And that's the reason why I'm here pro se. It's a position that does not sit well with me, but I certainly appreciate the court being patient with me, reading through all of my pleadings, and with that I will rest. Thank you very much, Your Honor.
Right, I think I need to retire just to be clear of the timeline of various documents. There have been some quite, to me anyway, novel submissions made, particularly by Mr. Murphy, and I just need to be absolutely clear in my mind in relation to the discharge of the injunction. So I'm going to retire for about half an hour just to go through some of those documents, and then I will give a decision on that. So far as the application for a stay is concerned, I continue to be of the view that I need information about the Maltese situation before I can give a decision on that. So I'll be inviting you both, I think, to agree a short period of time in which an affidavit can be filed from your respective lawyers in Malta, so I can be given up-to-date information about how long this case will take in Malta. So you can make a quick call to Malta now. It's up to you. Anyway, that's what I'm going to be doing on that. But yes, I need to just take these papers back to my chambers. So maybe my clerk and we can make arrangements to somehow haul these papers back for a short time.
Your Honour, just out of courtesy, I just thought I'd double check if Mr. Murphy has a flight this evening or not, but I doubt he has.
Oh, right, well, you're not about to leave us, are you, Mr. Murphy?
No, I'm fine for this evening, Your Honor.
Yeah, what time is your flight?
I don't have a flight today.
Oh, you do? So,
No, Your Honor.
no problem. Very good. Right, well, maybe...
And I will come back at approximately 4:15.
Okay. Your court staff has been wonderful, by the way. I meant to mention that. Ms. Klein and Ms. Kelly have been very helpful to somebody way outside of this jurisdiction, and I just want to compliment them on all of their efforts in dealing with it.
Everybody always says that. And
So, yes, you have a wonderful court staff.
Yes, I agree with that.
So, thank you, Your Honor.
Thank you.
Now, I'm going to give a short judgment in the matter of Mr. Murphy's. I say Mr. Murphy, that is to include Mr. Murphy and GCM Holdings Limited. I'll have a transcript of this judgment prepared in due course. But in essence, this is Mr. Murphy's application of 30th May 2016 to just discharge an injunction which was originally granted by Deemster Golddrain QC on the 19th of May 2016 and continued by me on the 2nd of June. It's supported principally by Mr. Murphy's skeleton argument of the 6th of May 2016. Because this concerns the grant of an interlocutory injunction, I have to consider whether there is a serious question to be tried, and clearly there is in this case. I have to consider issues such as the inadequacy or otherwise damages and the balance of convenience, as it is called in the case law. The essence of Mr. Murphy's submissions is that the evidence put before Deemster Golddrain in particular, and indeed still now, is and was patently false. He refers to Mr. Cannell's witness statement of the 17th of May 2016 and refers to various passages in it, and also in particular the evidence of Mrs. Murphy. I'm firstly unable to say that Mr. Cannell's witness statement is in any way false. Mr. Murphy focused on paragraph 4 of that statement, and in particular the statement that Mrs. Murphy had filed evidence with the Kansas court, or at least that is what I'm asked to infer. In fact, what Mr. Cannell says is that the evidence was filed with Crouchat's lawyers, and I can't see at the moment anything in the way of that being false or a false statement or misrepresenting the position. So far as Mrs. Murphy's evidence is concerned, this is perplexing, to put it mildly. She appears to have changed her position markedly from at one stage supporting Mr. Murphy to then supporting Mr. Halsall's plans. Her statements of the 2nd of May 2016 and 5th February 2016, which were filed in support of the injunction, are in marked contrast to a document of the 2nd of June 2016, and indeed an email very recently received by the court overnight on the 3rd of November, which supports a completely contrary view and would support Mr. Murphy's position. It is said that Mrs. Murphy was the subject of a bribe administered to her on the 5th of February 2016. It is said that she made her statement to Mr. Halsall's clients under duress. These are matters which it is impossible for me to determine at this stage. All that can be said is that there are real questions to be answered by Mrs. Murphy and perhaps others in connection with this rather murky matter. Ultimately, these are issues which can only, in my view, be determined at the ultimate trial of this case. Mr. Murphy also submitted that the court had been misled on the issue of the resignations of Mr. Cannell and his colleagues and their replacements by Mr. Murphy.
Essentially, he says that the full position concerning the resignation letters, to which I've been referred at length today, was simply not put before the court in an adequate way. I'm afraid I cannot accept that submission. The issue of the resignations was clearly before the court, and indeed is certainly before this court, very clearly in the form of the particulars of claim, which must have been before Deemster Goldrake. The whole issue of the purported resignations and the change of stance by Mr. Cannell and his colleagues is pleaded clearly and head-on, as it were, in the particulars of claim. The issue is very fully addressed there, so I cannot accept that Deemster Goldrake was misled. It seems to me still, looking at the evidence as it now stands, that the filing of the forms at the Isle of Man Companies Registry by Mr. Murphy was a misguided action, bearing in mind that the very issues which were the subject of the filings was before this court, and indeed also the courts of Malta and Kansas. It is certainly more than arguable that the filings, insofar as they related to Appleby being the registered agent on behalf of Crown Shout Limited, was wholly erroneous. So far as the further submissions made by Mr. Murphy are concerned, I was very interested to hear from him that there is apparently an order of the Kansas court which authorises in some way the resurrection of the website owned by Crowd Shout Limited. That website, I understand, to be called video2mp3.com, and authorises, or would enable anyway, the revenues from that website to be placed in an escrow account pending determination of the dispute concerning the ownership of Crowd Shout Limited. It is clearly, in my view, in everyone's interest for this to occur, and indeed I urge it to occur. However, I'm unable to progress the matter today because I do not have a copy of the Kansas order, and I would need either the agreement of the parties or an application to this court to vary Clause 5 and, to some extent, Clause 4 of the order of the 2nd of June, because it is said, and I think probably with some justification by Mr. Murphy, that this prevents, or those clauses prevent any operation of the website by Mr. Murphy from progressing. So if that matter cannot be agreed, I would urge that it be the subject of a variation application by either Mr. Murphy or one of the other parties to enable at least the revenue stream, which was, I'm told, very considerable indeed, to be resurrected. In summary, having considered all the submissions which have been made, I must say, most eloquently by Mr. Murphy and, of course, by Mr. Halsall, I consider that the balance of convenience continues to favour the continuance of the injunction, which preserves the status quo, which, in my view, is the position prior to the alleged changes in the directors and shareholders of Crowd Shout Limited in November 2014, a position which I believe to be reflected in the company's statutory books. I have, of course, considered the case of American Cyanamid, the well-known leading case on interlocutory injunctions, and the whole issue of the balance of convenience, which is otherwise said to be a balance of the risk of doing an injustice or the balance of justice. It is said in, I think it is the American Cyanamid case, that it is a counsel of prudence when other factors appear to be evenly balanced to take such measures as are calculated to preserve the status quo. In my view, a pragmatic solution to the current situation is for the injunction to continue. It will prevent at least the company's registrar from having to process possible competing registrations and notifications, although I am very conscious that Mr. Murphy has assured me today that even if the injunction were discharged, he would certainly not be making any filings pending the resolution of the unfortunate litigation in which the Crowd Shout companies are embroiled. that, I once again reiterate the need for this litigation, or whichever litigation is dealt with in whichever forum, to be resolved as quickly as possible. Insofar as the undertaking in damages is concerned, this is a matter where I think Mr. Murphy needs to take some careful legal advice, because I think there may well be an argument that the current undertaking in damages is somewhat inappropriate. The undertaking currently, as far as I'm aware, extends only to Crowdshout Limited and Crowdshout Holdings Limited. And it may well be that Mr. Murphy will be advised that the correct parties who should give the undertaking are other parties. And he, I think, mentioned today that it may be that he would wish the third, fourth and seventh defendants, Digital, Hearn and ICAP Malta, to be the subject of some form of undertaking. It's not a matter which I've looked into myself, and it's certainly not for me to give any advice to anyone, but that may well be subject of a further application. But I would say that Mr. Murphy needs to take specialist legal advice on that, because it's a very complex and difficult area. So my decision is that the injunction should stay in force for now, pending the resolution of this matter. But as I say, I do urge the parties to try to agree a variation which would enable the income stream from the website to at least be reactivated. That concludes my judgment on the issue of the discharge of the injunction. The only issues then which remain from this morning, and I just said this before I rose earlier on, the issue of the stay of the proceedings on the grounds of forum. We'll have to await further evidence from Malta, and what I'm minded to say is that I should receive from either side an affidavit as to the likely timescale for the resolution of the Maltese litigation. And I don't want a general affidavit telling me what the Maltese court system is all about and what the delays are and so on and so forth generally. I just would like to have some indication. I appreciate it may not be very precise as to when that case, the particular case involving Crowdshout, might be the subject of a final hearing. And what I would suggest is that I have that affidavit by, say, 7 days today. By the 11th of November. If that's going to cause you any difficulties, let me know, or if you think you can do it quicker than that, all to the good. And then I will give a judgment in writing on the issue of the stay application. So far as the application for judgment in default is concerned, Mr. Halsall, I don't think we can take that any further today. I have to say it's not an application which I'm sure would have found a bit to the table with me in any event, but there are a couple of points. First of all, Mrs. Murphy has not been served with the application, and really the relief which you seek is a matter which is going to have to be the subject of a contested hearing. Mr. Murphy, I think, will need to put in a defence. But anyway, we can deal with that. I need to first of all decide, of course, whether this is the correct forum for the matter to be dealt with. So perhaps I should simply adjourn the application for judgment to a date to be fixed. Right. So I'll have a transcript of that short judgment prepared, and there just needs to be an order drafting giving effect to the other two matters.
I'll draft it.
If you could draft an order, please, Mr. Also, I'd be very grateful.
I'll send it to Mr. Murphy for his approval.
Indeed. Anything else you want to raise at this stage, Mr. Halsall?
Normally, in the circumstances, I'd be asking for the costs with regard to the discharge application. As it's a discrete issue, and we would on it.
So you seek the costs of the discharge application?
Yes. Because it was an application which has been entirely unsuccessful.
Yes. Mr. Murphy, what do you want to say about the issue of the costs of the discharge application? It's the application you've made, which has been rejected by me at this stage anyway.
Certainly, Your Honor. That application was made in good faith with, I believe, reasonable arguments. If it turns out that I am correct and I control the claimants, then I think certainly that interim injunction should not have ever been ordered.
Yeah.
I think we can agree on that. And so if there were going to be any costs to be determined, I think that would have to wait until final determination as to who controls the claimants.
Yeah.
On the issue of costs, I don't know if Mr. Hossel is going to pursue his second application, but I would say that if he does so and a date is set in the future for that application to be heard, that I would be compensated for my cost of reappearing here in the Isle of Man to defend that application. It's certainly not my fault that Mr. Hossel did not notify Gina of either, Mrs. Murphy of either the application nor this hearing. And so if I'm going to have to be put through another considerable expense, I think it's very fair and reasonable that the other side should compensate me for that. So as to Mr. Hossel's request for fees, I don't think that's a reasonable request, and if the court were inclined to consider it, I think it should only be taken up at which time we have final determination of the claimants.
Yeah.
Thank you, Your Honor.
Thank you very much, Mr. Murphy. Mr. Olson, anything else you want to say on that issue?
No, simply just the argument would be the cost following event on that individual application. And obviously any costs of any other applications could be dealt with when they are determined. But the usual order would be costs to be taxed in the default agreement, and it would be at the end of the case in any event.
Thank you very much. Well, I agree with Mr. Murphy on this issue of costs. This is clearly by no means a straightforward matter, and the whole issue depends ultimately upon who is adjudicated at the end of the day to control and own the claimants. And as Mr. Murphy rightly says, if he is correct that he is indeed the owner of the control of the claimants, this injunction should never have been ordered in the first place. It would be unjust, I think, in the circumstances to award costs against him in respect to this matter. The injunction will continue, but it is one which is made without any prejudice whatsoever to the merits on either side, which it seems to me I'm simply unable to adjudicate upon at this stage. It is by no means a straightforward matter. So I will reserve costs until the conclusion of the proceedings.
Right, sir.
Right, I think that deals with everything. Can I just thank you both for conducting the proceedings in a very civilised and helpful way. In particular, Mr. Murphy, your submissions have been a great help to me. They've been very eloquently put. I think it emphasises that an appearance in person is extremely beneficial to the court. I know there was an attempt by you to have the matter dealt with by video conferencing. Quite frankly, I think that would have been a bit of a disaster. And with the greatest respect to you, and it's been of enormous benefit to me to have you here in person and for you to address me, and the sort of interaction that goes on is far more satisfactory in a matter of this complexity. If there are further hearings, which there may well be, for example, if there's this variation application, I would certainly very much prefer it if you could come here in person, and I very much hope you will be able to do that. I appreciate it's a matter of considerable defence, but we will endeavour to accommodate your appearance in person if we possibly can, because I think it's highly advantageous to all concerned to do it that way. So thank you for your assistance, Ms. Halsall, and particularly in sorting out the bundle, which I think was a very, very good piece of work, very important to the discharge matters today. Unless there's anything else, then we're now adjourned. Thank you very much. Have a good weekend.
Thank you, Your Honour.
Thank you, Your Honour.